What's up? It's Saturday, May the 8th. Welcome to another Operation Wisedome. I don't know the episode number. We don't count the numbers. We just keep going forward, episode after episode after episode. Today, what we're going to be doing is going into information in relation to my civil suits. Yes, I got some civil suits. I got a couple of them. Actually, I think I got three of them now. And then it's lawsuit season, so people are just bringing forth lawsuits like crazy. We got Kane, we got Robin bringing forth one, we got Dan bringing forth one, Hayden bringing forth one, we've got Robert bringing forth one. I mean, we got lawsuits all over the place. So, yes, it's lawsuit season for Operation Wisedome, and we're not playing with it. Everybody's bringing forth a lawsuit because, yes, we out here getting violated in ways that we shouldn't be getting violated for. We know our rights. We know that our liberties. We know what's owed to us, what duties supposedly granted to us, because, of course, all power is inherent in the people, and our servants are to continuously serve us. And when they don't know the process of the law and they violate the law, whether it be by ignorance or design, they must respond in damages. Yes, that is case law, and it is very clear that they must do so. Hey man, I'm just out here trying to live my life. I don't really like to sue people, but when people are ignorant and we must sue people, that's just what we got to do because, hey, they're not honoring their oath, not only to the people, but also to God. And so we want to make sure to stay on top of that. So if people have really not been following my situation and what's been going on, yes, the docket numbers are out there. You can clearly find them all over the internet. But there's been a kind of a gap in between letting y'all know what's been happening and what hasn't been happening and what I've just brought forth here recently. I think about 2 weeks ago, I brought forth my third lawsuit against Ridgefield, Washington Police Department, and I think just two of their officers. That was it. That was 2 weeks ago. What we did on this last one was we did it in form of pauperous. I filed indigent, essentially. And I also filed via email. So I was able to, here in Tacoma on the Western District of Washington, they have eligibility for one to literally just email over your complaint and your cover letter or your cover sheet, and you can get a case number. And you have to wait, of course, to get your summonses. But nevertheless, you can just file via email and inform a pauperous. And I did so about 2 weeks ago and been wanting to get the experience just to see how long one might have to wait when you file indigent. And then also just the response and the treatment that you're getting versus one who does pay 405. And so I'll be keeping y'all up to date on that. But as of right now, yeah, the next day after I sent in an email, I got a case number. But again, it's been 2 weeks since I filed, so it seems as though things might be moving a little bit slow as far as getting your indigent status approved and getting your summons to then send out to the correct defendants and or agencies. So just be aware that's what I've been experiencing thus far, but it may be for some other reasons too. Either way, then for the secondary lawsuit right now, which is WSP or Washington State Patrol against David Schoenborn and Sergeant Hovinghoff. Yes, we just did a response for them. What is this? 2 days ago? I think 2 days ago. And I kind of wanted to go through that before going through Hood River and showing y'all what we're going to be submitting for Hood River, which we have not submitted yet. I think I have what, 10th, the 11th? I think I got till the 11th, actually Monday, end of day Monday to actually file for Hood River. So yeah, kind of crazy, but we'll be filing it, cutting it close. But I could probably just file today or tomorrow, and it wouldn't be an issue whatsoever. We're already done on that angle. So yeah, other people have been bringing forth lawsuits. Like I say, Kane's in this thing. Who else we got bringing forth a lawsuit? I don't know if, yeah. Oh, Robin. I know Robin's going to be bringing forth a lawsuit. He's got his complaint drafted up. But yeah, I know as of right now, Kane's about ready to file in this thing. James is about to file his. He's got a big lawsuit. Yeah, we just did a whole bunch of drafting and finishing up on yours, didn't we, Kane?
Yep.
Yeah. So you
Got
about
got
ready.
it all ready to just hit print.
Yeah, you about ready to go too. And I think James was just talking about printing off all of his complaints. Is that correct?
Oh, ready
That's what I'm
this
telling you.
week.
So yeah, so we got a lot of people bringing forth lawsuits. It is lawsuit season. People have gotten through their cases and gotten through the dismissals or haven't gotten anything moving whatsoever, and they're just ready to move forward because of the situation at hand and the irreparable harm that's been served and caused to them. One of the first things I wanted to go through, let me see real quick if this was it. Yes, is in my Hood River case, or not Hood River, in my Washington State Patrol case. What has happened is just due to some things in life, life happens, right? Is that for my Washington State Patrol case, it hasn't run as smooth as my Hood River case. And what I mean by that is that I haven't gone ahead and done my depositions on my Washington State Patrol case yet, even though it's been a while since I filed that complaint. Reason being is just life issues, things that have come up in life that have just been put on the forefront rather than doing the depositions. Even though I've gotten the discovery, I've done interrogatories, things like that, I still haven't deposed them. In the process of not deposing them yet, what has ended up happening is that they went ahead as far as the Assistant Attorney General, who is the defense for them as far as the attorney that is working this situation for both Officer Hovinghoff, Sergeant Schoenborn, is the Assistant Attorney General of Washington, is working the defense for them. And in such, they went ahead and just filed for summary judgment without having any depositions being done whatsoever. And that honestly is just in relation to a lack of me proceeding forward and requiring them to do what they should be doing, which is setting up depositions, moving forward with expert witnesses and things like that as far as that is concerned. But one of the things I thought that was very interesting is that in the process of filing their summary judgment, what they ended up doing is they ended up bringing in this apparently expert witness. Okay, and this expert witness is very funny, and I wanted to kind of go through this with y'all. And if y'all don't know which situation I'm talking about, I'll show y'all just real briefly. Hold on, stop share, share sound, share, and then we'll just do, what are we doing? I guess we'll go to view channel, videos, and we'll come down. I think it's just WSP number 1. Let's see. Where we at, man? It can't be this far down, is it, bro? Oh, there it is. I guess it is. Okay, so this one. Getting back.
Five ten golden stopping. What's going on? What's that?
You're not gonna violate my rights today.
What are you talking about? I'm seeing if you're okay.
I'm okay.
I'm seeing if you're okay. Wasn't a traffic stop. There was no nothing. It's a welfare check, okay? This is a welfare check.
Okay.
You're not gonna violate my rights today, okay? I don't need your service.
Can you step back to your car, please?
No, I'm not gonna
Step back to your car right now.
What do you mean?
Step back to your car.
You suspected me of committing.
Nothing.
Okay.
What crime have you suspected me of committing? Nothing.
You have license.
Wait.
Stop. Let me talk.
Whoa.
You have license plate covers. That's illegal in Washington.
I'm
Get
not-
back in your car.
Dude,
Get back in your
call
car.
Your sergeant.
Get back in your car.
I'm not gonna take the bands from you.
Get back in your car.
That's not how this
Get
works,
back
bro.
in. This is exactly how
No,
it
it
works.
doesn't. I have
Get back in
constitutional
your
rights.
car.
I'm not getting back in my car.
Good for you. Get back in your car.
I'm not obeying an unlawful command.
That is a lawful command. Get
No,
back in your car.
I'm not getting back in my car. Call your sergeant, dude.
Five ten Roosevelt, North 97 at 3. He's combative. Can I get another unit out here?
Requesting additional unit combative emergency traffic only.
Oregon Sam Lincoln 3 99211.
And he just read my license plate. So clearly, the license plate cover is not obfuscating eligibility of him to read, even sitting this far away.
Get back in your car.
Right? So that's what this situation is from. Okay. Now, what they went ahead and did is they went ahead and got them apparently an expert. Okay. And this is actually pretty funny. This is some of the things that you can expect, but we'll go through how to eliminate some of these things as well. Okay. Because it's pretty funny. All right, let's get Chris in here. So at the request of the attorney for the defendants, I reviewed the actions of Troopers Schomburn and Sergeant Hovinghoff during the handcuffing, post-handcuffing, custody, and booking of the plaintiff, Cameron Wilson. Apparently, this is someone they would like to utilize as a witness, right, in a trial or anything like that to help support their summary judgment, right? But this is very biased. Qualifications. I retired after 30 years of police service with the Seattle and Auburn Police Departments. I was most recently assigned to the force investigations team at the Seattle PD, where I reviewed and responded to investigations involving the use of deadly force. Prior to that, I was assigned to the force review unit at Seattle PD, where I reviewed use of force cases that were completed by the chain of command. Prior to that, I was assigned to the Office of Police Accountability, OPA, for the Seattle Police Department. OPA investigations, allegations of misconduct against Seattle police officers. As a detective sergeant in OPA, I was charged with investigating and reviewing allegations of misconduct made by citizens and the chain of command. I was promoted to the rank of lieutenant while assigned to OPA. In that role, I supervised and evaluated the work of 4 to 9 detective sergeant investigators investigated alleged misconduct by command staff, and I made recommendations for classification and findings of our investigations. So you're a bootlicker, essentially, right? You're career gung-ho, back the blue is what you're telling me. Additionally, as part of the OPA command staff, I responded to deadly force cases while on call and provided an oversight role of those investigations conducted by the force investigation team. So you're essentially telling me that you've seen the worst of the worst as far as situation is concerned, and seeing something like this, you would say is no big deal. Essentially, is what you're trying to tell me. Okay, cool. Prior to my assignment in OPA, I was assigned to the Education and Training Section, ETS of the Seattle Police Department, for about 7 years. I was acting lieutenant of that unit just prior to my transfer to OPA. Great. Whatever, dude. I formally taught use of force decision making. Great, yes. You're letting us know how you're a career cop, right? My experience includes patrol and detective work. You're a career cop. While I was supervising, keep going. He's just going on about his training and just about everything. Just trying to give us everything as far as his experience. He's just a career cop. In preparation of this report and forming the opinions expressed, I have reviewed the following documents and materials. So the complaint, their answer, video, all of the videos. Apparently, he's viewed all of the videos. And he states that my opinions are expressed based on my training and experience in law enforcement and working as an expert witness for over 25 years. I give these opinions on the most probable than not basis. The opinions that follow are subject to revision as discovery progresses in this lawsuit. So the handcuffing officers have been trained in methods to handcuffing. Handcuffings are inherently uncomfortable restraint. The model currently in use for handcuffing throughout most of Washington state is the Crest model. Prior to the attempting to complaint arrest, it is also clear from the dash cam video that Trooper Schomburn is looking at traffic. Reasonable officer has been trained that there is a significant danger, by being by struck. Prior to handcuffing Mr. Wilson, Trooper is attempting to use the compliant handcuffing techniques as been seen in both dash cam. For example, Trooper Schomburn directs Mr. Wilson to turn around and tells him that he is under arrest instead of complying. So I have to just comply, apparently to this guy, Mr. Wilson, to turn around and tells him that he is under arrest instead of complying. Mr. Wilson is physically non-compliant and argumentative. Well, I can be. There's no crime that's been committed. Trooper Schomburn, but of course, just by stating that, it's to try and make me look bad. Trooper Schomburn even tells Mr. Wilson that he is under arrest. Why? What he is under arrest for when asked by Mr. Wilson. No, he doesn't. I ask over and over and over. I never got a reason for why I was being arrested. What was I being arrested for? Not providing ID? I don't have to provide ID. Trooper Schoenborn even tells Mr. Wilson what he's arrested for. It's not true. This is consistent with the compliant handcuffing process. Mr. Wilson responds with argument and movement away from Schoenborn. A reasonable officer would interpret the behavior of Mr. Wilson as non-compliant. Yes, I don't have to abide. And verbal coupled with active aggressive resistance. Makes physical contact to initiate the handcuffing using what looks like trained technique. Uses right arm to turn at Mr. Wilson's body to control. Escort. The purpose of this entry is to cover the physical distance from the officer and the subject from being handcuffed safely. Mr. Wilson turns towards Trooper Schoenborn. This turning action would be considered continued resistance by a reasonable officer. So me turning to ask the Trooper Schoenborn, why is he doing this? Apparently, this action could be considered continued resistance by a reasonable officer. In response to this continued resistance, Trooper Schoenborn uses a push to move Mr. Wilson to a facing away position. This push would be considered bodily force, and in my opinion, would be considered by a reasonable officer on scene at the least amount of physical force necessary to accomplish the handcuffing procedure. I should have never been handcuffed. There was no crime that had ever been committed. Post-HUD handcuffing. Once Mr. Wilson is placed in handcuffs, Trooper Schoenborn escorts him to the patrol vehicle car, which is standard procedure. It is evident that Trooper Schoenborn maintains physical control of Mr. Wilson during the escort, which is a trained tactic. So again, dude is just going into, I believe, a reasonable officer watching Mr. Wilson's entry into the patrol car will believe that he was able to do so without any difficulty. Well, it was difficult. I was in pain, most definitely. But you giving your basis, even though you're not a medical officer, you're not medically trained by any means. You hold no degree in any medical format. So for you to say it would be reasonable to believe, you have no clue how difficult it was and how much it was hurting. I believe that a reasonable officer would believe that it was consistent with trained practices to seatbelt Mr. Wilson. I've told you that I can't bend my leg a certain way. He's going over me trying to make phone calls in the back, but that they take away my phone. In my opinion, I believe that a reasonable officer on scene at the time when Mr. Wilson is removed from the vehicle or a pat-down search would believe when watching his movements that he did not need medical treatment or accommodation for his disability. Yeah, so they're essentially just utilizing this guy that is an expert policeman to kind of back up their situations. And he's going into his publications. So he's got all these publications on things that is from his website that he believes kind of backs up the situation as far as what is going on. Then he says, if I want to depose him, I don't know what it was. It's like $450 an hour. Yeah, including time travel. 4 hours will be billed at 8 hours. For 8 hours will be at 12. So to depose him,
Then that's not up. That's not up. Yeah, just get it all spread out.
Yeah. So this guy's, dates of availability. He's trying to let me know all of when he's available, who he's testified for previously, which one has been Washington State Patrol. See the bias here. It's not one that is neutral. It is one that is very law enforcement. I mean, look at how many, things he's testified to on behalf of police, which is really, I want to say, okay, cool. You can call yourself an expert in a certain sense, but the bias and the prejudice here is a little bit weird. And then any kind of testimony or anything is $450 per hour, right? So it seems like the state's already spent quite a bit on him to try and get his testimony in to assign in the training aspect of validating that his training is consistent, or Schoenborn is his actions were reasonable within the training, right? But the training is actually inconsistent with what's true and what's real out here. And I think that's one of the biggest problems, is that law enforcement agents are being trained really, really, really wrong. Or the enforcement, as far as they're not being trained all the way on what are the requirements. Like when they speak on Pennsylvania versus MEMS, it's pretty understandable, and it's well known that they there has to be some kind of danger being posed against them in some form or fashion. And so what we've had happen is that they've gone ahead and filed this summary judgment, and they went ahead and filed the summary judgment fairly quickly while I was in the hospital. And instead of me going ahead and filing for a extension or a continuance on trying to get more time to respond, I just said, you know what, I'm gonna crush out pretty hard, and I'm gonna go ahead and respond. And so normally how the process would go is you would file your complaint. Once you file your complaint, you would get back an answer or 12B6, which is a dismissal, a motion to dismiss the case. You would do a couple of responses to the motion to dismiss, or you would do an amended complaint. Once you got through that, there would be a case scheduling assignment with the judge, and they would pretty much just set time periods for certain things that should happen at certain times, whether it's discovery or when the trial should come upon. And then you would go into requests for production and interrogatories and discovery from the defendants, and they would do such as far as you or from you as well. And then you would move into depositions, right, and start questioning the defendants. Me, on this WSP one, I have not questioned or done any depositions. So they just said, well, since he's not doing depositions and we haven't heard from him for quite some time, let's just file for summary judgment. And so let me check to see if it's in here. I think it's in here, but declaration, proposed order. Let me see which one it is. It might just be this one. No, it's the one below, I think. Material facts in support for summary judgment. Motion for summary judgment. Let's see. Okay, so they just went ahead and moved for summary judgment, right? So they said relief requested, stopped alongside near Washington on the border to check on the driver of a silver sedan. He was greeted by Mr. Wilson, requested to return. And Mr. Wilson stated that he would not follow an unlawful order. Wilson then began to walk down the highway after choosing not to identify himself. Well, don't have to. He was arrested for his choice. Oh, yeah, you want to put forth that he was arrested for making that choice. Wilson subsequently provided his name to Sergeant Holdinghoff, who arrived at the scene at Mr. Wilson's request. Actually, I provided it to. This is a complete lie because I provided it directly to Schoenborn. Trooper Schoenborn then transported Wilson. So, see, I mean, right here in their very beginning, this is a complete lie. So what they're presenting to the court is not consistent with what's on the record or the body camera, because I provided my name to Schoenborn, not to Holdinghoff, right? So that's a dispute right there of material facts. I mean, that's something to be disputed. I didn't give my name to Holdinghoff. I gave it to Schoenborn initially, which is just goes to see how they make mistakes and how, again, like there's an issue when there's a disputed fact in your motion, in your summary judgment request. Because again, bro, I gave my name to Schoenborn. I didn't first, not to Holdinghoff, who arrived later. Trooper Schoenborn then transported Wilson to Klickitat for booking because there was no probable cause to detain and then arrest Mr. Wilson. This court should dismiss the claims against the defendants. Because there was probable cause, well, let's just ask this question. If there was probable cause to detain and then arrest me, why did the prosecuting attorney immediately dismiss the case before arraignment? If there was probable cause to detain and arrest me, then why was the case dismissed by the prosecuting attorney before even arraignment?
The statement don't align with the facts.
At all. Even if the court determines probable cause did not exist, defendants are entitled to qualified immunity and the claim should be dismissed. You don't get qualified immunity when you know the law, okay? Or anyone should reasonably know that you don't get to just arrest people just because you want to. Okay. Accordingly, defendants move this court ordering granting summary judgment. So they're going through the facts, right? They're bringing forth their side of facts here. Was traveling when he stopped his vehicle on the shoulder to rest and assess his route is what they wanted to say. You know, I don't know why they said I was wanting to rest or assess my route. I guess that's just what they're bringing forth. I could literally dispute that. No, I was going to relieve myself. I wasn't resting. You see what I'm saying? Troopers on patrol had observed a silver sedan. Declaration, trooper stopped to see if driver was in distress and if assistance was needed. Right? That's, again, a caretaking stop. The cover made it impossible for Trooper Schomburn to see the expiration date on the license plate. Well, even if that was the case, you could read it into the system and look through your system. But what they're doing right here is they're saying he observed tinted license plate covers, which is illegal in Washington state. Okay. What they're not doing is they're not telling the truth. It is illegal for Washington residents and Washington drivers. It is not illegal for those who have residency in Oregon and or their vehicle registered in a foreign state. Okay, and there's declared exemptions in the statute that make it very clear. Okay, so I think it's very odd. But the cover made it impossible. Before Schomburn could completely come to a stop, the single occupant of the sedan exited the vehicle. Okay. So before, again, he could come even to a stop, I exited the vehicle and approached him while yelling something unintelligible. Again, that's a misrepresentation because I never yelled whatsoever. Okay. Trooper Schomburn asked if he was okay. Mr. Wilson stated he was fine. Demanded that Mr. Wilson get back in his car, and Wilson refused. He informed that the license plate covers are legal, requested Mr. Wilson's license, and Mr. Wilson refused. And, you know, Wilson still chose to refuse. Okay. So they're bringing forth this summary judgment where they feel as though there's no probable cause and everything's okay for them to do. They're saying they witnessed a misdemeanor. No. Okay. You didn't witness I don't know what misdemeanor they would have reviewed. Arrest without a warrant was committing a misdemeanor when the offense is committed in the presence of the officer. What? Washington Code Revised Code. What? Here, trooper witnessed the misdemeanor. What? Not IDing? That's what this one is. 1031-100. Not IDing. That's what they're trying to say here. Is that they witnessed me not IDing. That was the misdemeanor. That's why I deserve to be arrested. That's not how this works, bro. That's not how this works. At all. Trooper Schomburn asked Mr. Wilson if his choice to not identify himself was driven by the outstanding warrants. Trooper Schomburn was then provided, and they never confirmed any of the warrants, so I don't know why that was even utilized anyways. While the outstanding warrants went unconfirmed, exactly. So, which is meaning I should have been let go. Trooper Schomburn proceeded to transfer Wilson to Clicketown County and booked based on the misdemeanor charge of failing to identify, which was well within his authority under 1031. No, it wasn't. Not even close. Even if probable cause to detain did not exist, defendants are entitled to qualified immunity. No, they're not. Not even close. Mr. Wilson's First Amendment claim fails because the arrest was supported by probable cause. No, it wasn't. There was no probable cause. You literally said you were doing a welfare check. You were checking to see if I was okay. So there's no probable cause of crime. And yes, there was evidence of retaliatory animus because when I didn't get back in the car and I said that's not how this works, you said yes, it is. They know better. That's why I say I really need to get these depositions in, and they're going to be really good. But they're coming through with their motion for summary judgment, right? And so we've said, okay, we haven't done depositions yet. Let's go ahead and give a response because we got to respond to them. So let's check out the response that I got for bringing forth. Okay, and shout out to Joe and shout out to Steele or Sam for when I brought forth something. They kind of did a review of it and was kind of making sure, I was on my toes, iron sharpens iron before we did a submission. So we're going to go through some of this, the introduction and the philosophical and legal foundation. The defendant's motion for summary judgment rests upon a foundation of legal mischaracterization, factual distortion, and a constitutional error so fundamental as to render the motion legally unattainable. Defendants ask this court to hold, as a matter of law, that 2 Washington State Patrol troopers acted constitutionally when they, number 1, converted a voluntary welfare check into a coercive, warrantless detention of an individual who was lawfully parked in a designated area with his vehicle's engine off. 2, demanded identification from a person who had committed no traffic infraction and was not operating any vehicle, a fact that explicitly acknowledged on scene by defendant Hovinghoff, who stated that they would not cite for traffic violations because they did not observe plaintiff driving. 3, arrested that person for failure to identify, a charge that the prosecuting attorney authority dismissed upon initial review, providing powerful corroborating evidence of the absence of probable cause. That's why they never towed the vehicle either, and they released it directly to my family. 4, failed to, and this is without insurance, without registration, right? There was no valid registration. There was no valid insurance, but yet still, they didn't tow it, and they released it to my peoples, right? So 4, failed to make any reasonable accommodation for that person's known visible disability as a below-the-knee amputee. 5, seized that person's cellular telephone without a warrant while he was exercising his First Amendment protected right to record a public law enforcement encounter. And 6, subjected that person to a detention and arrest motivated, at least in part, by retaliatory animus for his constitutionally protected speech. The fundamental rights asserted herein derived not from the governmental, but by the Creator. Plaintiff respectfully submits that the foregoing course of conduct presents genuine disputes of material fact on every claim asserted in the second amended complaint, and that the qualified immunity does not shield defendants from liability. Okay? So the statement of genuine disputes of material fact. Nature of the encounter. Defendants characterize the initial contact as a lawful investigative stop. Plaintiff disputes this characterization and asserts that the encounter was a voluntary welfare check, a consensual encounter that plaintiff declined, after which defendants had no constitutional authority to detain him. Now, let's say that once I said, "Hey, man, you're not going to violate my rights, leave me alone." And he says, "Oh, but you have license plate covers." The only reason that he could initiate contact on license plate covers was if that he saw me actually operating the motor vehicle or a motor vehicle or in operation of a motor vehicle. Okay? Once he saw me, so if, his best bet should have been, "Oh, well, you got license plate covers." "Well, I'm not driving." Okay, well, you got me on that one. I'm actually going to wait here for the next hour to see when you drive off. You see what I'm saying? You could have done that. Could have waited to see if I would have been and started to travel off. That would have gave him justification. But me being parked, it don't work like that, bro. It don't work like that.
Right. The cop didn't know if you was a passenger or he just seen the automobile and you. He don't know how y'all got there, nothing. It's
Correct.
crazy it's crazy how I want to call them Play-Doh cops because they take the facts and they knead them around like Play-Doh and twist them into something totally different.
Exactly. So, defendant's own sworn declarations confirms the officer stated it was a welfare check. Okay, so that's straight up off the bat. 2, whether Wilson was operating a vehicle. Defendants assert the encounter arose from a traffic investigation. Plaintiff disputes this and asserts that the vehicle was parked in a designated area with the engine off for approximately 5 minutes prior to that encounter, and that he had exited the vehicle to relieve himself. So no traffic infraction was occurring. The mere presence of a person in the driver's seat of a parked non-operating vehicle does not establish operation of a vehicle within the meaning of an applicable statute. Whether any traffic infraction occurred, defendants claim the license plate cover provided reasonable suspicion, but plaintiff disputes this and asserts that his vehicle was registered in the state of Oregon, and that RCW 4616A 1601B expressly exempts out-of-state registered vehicles from Washington's license plate cover requirements. Why is that? Because how is any other resident through any other state supposed to get notice that license plate covers are illegal? They're not. They're not residents. They're not residents. So if they're traveling through, they are just to obey the state that they're registered in, not any other states that they travel through to. And literally, it's expressly exempts me under the statute. So I'm under an exemption. But apparently, Officer Schonborn didn't educate himself and read thoroughly. He knew the license plate covers were illegal, but didn't read or understand the exemptions that applied. Not my fault. Qualified immunity doesn't apply. You should have reasonably known that. If you knew the statute was illegal, you should have known the exemptions also that apply to the statute. Furthermore, defendant Hovinghoff explicitly admitted on scene that they would not cite the plaintiff for traffic violations because they did not observe him driving. Well. 4, whether defendants knew the plaintiff's disability. That's a dispute. Number 5, whether plaintiff's conduct constituted abnormal behavior, justifying detention. 6, whether plaintiff's refusal to engage provided reasonable suspicion of a crime. Number 7, whether probable cause existed for arrest. Defendants assert probable cause existed based on failure to identify. Plaintiff disputes this and asserts that RCW 46.61.021 applies only to persons stopped for traffic infraction, that no traffic infraction occurred, and that the prosecution's dismissal of all charges upon initial review is powerful corroborating evidence that no probable cause existed. 8, whether plaintiff's phone seizure was seized unlawfully. Number 9, whether defendants provided reasonable ADA accommodations. Number 10, whether defendants used excessive force, the legal standard. So summary judgment is appropriate only when there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. A fact is material if it might affect the outcome of the suit under the governing law. A dispute is genuine if the evidence is such that a reasonable jury could return a verdict for the non-moving party. At the summary judgment stage, listen here, a court must view facts and draw all reasonable inferences in favor of the non-moving party. Through this again, that means me. I'm not the one moving for summary judgment. At summary judgment stage, the court must view all facts and draw all reasonable inferences in favor of the non-moving party. I'm not moving for summary judgment. So all the facts, okay, must draw all reasonable inferences in favor of me. The court must. All of them. Okay? The court may not weigh evidence or make credibility determinations. Okay. Further, where video evidence exists, the court must view the facts in the light depicted by the videotape, not by how they want to depict it in their declarations and their viewpoints, but literally how the video shows it. The video shows someone parked, vehicle not on, someone getting out before being stopped, saying, "Leave me alone. It's a welfare check." Hey, that's it. And you didn't leave me alone. The summary judgment standard is applied with particular care as, quote, the issues in such cases frequently involve disputed facts and the credibility of witnesses. Okay. The argument, the initial encounter was a consensual welfare check that plaintiff lawfully declined and defendants had no authority to convert it into a coercive detention. A welfare check is a consensual encounter, not a Terry stop. Okay. So we're bringing in those arguments there. Critically, a citizen approached during a consensual encounter has the absolute right to refuse and to decline the encounter and walk away. Okay? I have every right to walk away. A citizen's refusal to cooperate with a consensual encounter does not, stand alone, provide reasonable suspicion to justify a Terry stop. Florida versus Bostick. Refusal, quote, refusal to cooperate without more does not furnish the level of objective justification needed for a detention or seizure, unquote. Just can't happen. Sorry, bro. What you did was illegal, my G. Sorry. Number 2, to the extent community caretaking exemption, to the extent defendants invoke the community caretaking doctrine to justify the warrantless intrusion upon plaintiff's liberty, this argument was definitively foreclosed by the Supreme Court. Okay, and Canaglia, the court unanimously held that the community caretaking exemption to the Fourth Amendment's warrant requirement does not extend beyond the automotive context in which it originated. and rejected the proposition that community caretaking constitutes a freestanding exemption to the Fourth Amendment that permits warrantless intrusions whenever officers subjectively believe they are acting in caretaking capacity. The court in Caniglia reaffirmed that the touchstone of the Fourth Amendment is reasonableness, and that the government bears the burden of establishing that a warrantless seizure falls within a recognized exemption to the warrant requirement. The welfare check does not constitute such an exemption. Once plaintiff told the officers to leave him alone, the consensual encounter was over. Any continued detention thereafter constituted an unlawful seizure under the Fourth Amendment. Got him. 3, plaintiff's vehicle was parked in a designated area with the engine off. No traffic infraction occurred. We already know this one. Okay, and the elements upon which we're going under is RCW 46.61.021 is therefore misplaced. The statute provides in relevant part 1. Any person requested or signaled to stop by a law enforcement officer for a traffic infraction has a duty to stop. Wasn't in traffic, can't have a traffic infraction. 2, just because you're on the side of the highway doesn't mean you're in traffic, bro. That's not how this works. 2, whenever any person is stopped for a traffic infraction, wasn't stopped for a traffic infraction. The officer may detain that person for a reasonable, wasn't in a traffic infraction. 3, any person requested to identify himself or herself to a law enforcement officer pursuant to an investigation of a traffic infraction. Well, he was just asking me if I was okay, making sure I was all right. Wasn't no traffic infraction, so don't have to identify. So every subsection of the statute requires a predicate condition that the person be stopped for a traffic infraction. No traffic infraction occurred here. Okay, so again, they can't request any ID. The mere fact of sitting in the driver's seat does not establish operation of the vehicle. I could just be sitting in the driver's seat, and somebody else could have been driving the whole time. They don't know who got picked up, who was following, who went to the store to go get gas if I was out of gas. None of that shit, right? So just because me sitting in the driver's seat does not mean I was the sole occupant or the one even bringing that vehicle or automobile to that point and or location. 5, the detention was unlawfully prolonged beyond its permissible scope. Okay. The arrest of the plaintiff for failure to identify lacked any probable cause and constituted an unlawful seizure in violation of the Fourth Amendment. Okay. Bringing these arguments in, the prosecution's dismissal is a powerful corroborating evidence of no probable cause, which they're trying to bring forth that they did have probable cause to make the arrest, but that ain't gonna hold. The warrants were never confirmed, yet the arrest proceeded. The arrest violated Article 1, Section 7 of the Washington Constitution. Defendants used excessive force. Okay, they didn't meet any of the Graham factors. Okay, there's actually 4 different Graham factors, or maybe just 3 of them. I thought there was 4, but we utilized this in Hood Rivers, which we'll go over as well. Which is the Graham factors are the reasonableness standard. Okay, on making a seizure based on your Fourth Amendment, based on the Fourth Amendment. Again, this requires careful attention to the facts and circumstances of each particular case, including 3 primary factors of the Graham, or 3 primary factors, which are known as the Graham factors. 1, the severity of the crime at issue. There was no crime. Okay. 2, whether the suspect poses an immediate threat to the safety of the officers or others. Nope. Was attempting to walk away. So even if he needed to call it back up or anything like that, I mean, I couldn't have gone too far. It was literally on the side of the road. So he could have not even arrested me or attempted to arrest me or put his hands on me. And if he needed other backup to come, where was I going to go? Right? Then 3, whether he is actively resisting arrest or attempting to evade arrest by flight. Well, what was the crime in which you were making an arrest on? Right? So I couldn't be resisting arrest or evading arrest if you didn't have a valid reason to arrest me, if you didn't have a valid probable cause to arrest me anyways. Right? I couldn't be evading arrest if you didn't have anything truly to arrest me for. So I couldn't be actively resisting or attempting to evade because there was no crime. The reasonableness inquiry is objective. The question is whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them without regard to the underlying intention or motivation. Okay. Let's see. The application of the Graham factors demonstrates disability-specific unreasonableness. First, the severity of the crime at issue was non-existent. There was no crime. Second, the plaintiff posed no immediate threat to the officers whatsoever. I was actually trying to walk away. Third, plaintiff was not actively resisting or attempting to flee. I wasn't trying to run away from a true crime. Okay? Maybe I was trying to, wasn't resisting your arrest. Maybe I was refusing to obey your unlawful commands, but I was not actively resisting a valid arrest or attempting to flee from a valid arrest. Okay? Then we have the use of force against a known disabled individual heightens the unreasonableness. Qualified immunity does not shield the defendants because the constitutional rights at issue were clearly established. Okay, so the qualified immunity standard. The right to decline a consensual encounter was clearly established. The right to be free from arrest without probable cause of a crime is clearly established, and they know that. The right to be free from excessive force, as far as being put in handcuffs without a crime, is clearly established. The right to record police was clearly established by the Ninth Circuit. The ADA application to arrest was clearly established. I even let him know, listen, man, I'm an amputee. Okay, I got one leg. Okay, if you arrest me, you know that that's going to be a violation. Still, he arrested me right there on the spot. Defendants violated the First and 14th Amendments by seizing plaintiff's phone without a warrant. The right to record police is protected by the First Amendment. The seizure of the phone was unlawful and retaliatory. The seizure of the phone was also fruit of the poisonous tree. Defendants violated Title II of the ADA, right? American Disabilities Act. There should have been no force that was applied to me whatsoever, nor should he even attempted to pull out what he did. He pulled out his taser and was, and I'm like, damn, bro, you really about to shoot me with the taser, dude? Like, whoa, what are you doing here? Defendants had actual knowledge of the plaintiff's disability, right? Straight up stated it to him. And they failed to provide any reasonable accommodation to my amputation. Plaintiff's disability was effectively criminalized. I was pushed and shoved, and it was labeled by the expert that came and gave testimony as active resistance. When I said, hey, man, please stop shoving me, that hurts. Exigent circumstances do not excuse the failure to accommodate. Sergeant Hovinghoff is liable under Section 1983 for all supervisory liability and failure to intervene, right? The duty to intervene. Then we come through, what else do we have here? Defendant's expert Thomas Ovens should be excluded under Federal Rule of Evidence 702 and Daubert. Okay. Now, the reason I'm going through this is because, like I told y'all, they brought forth someone who's like, oh, yeah, expert testimony, right? Let's go through this. The Daubert standard for expert testimony. Under Federal Rule of Evidence 702 and Daubert versus Merle Dow Pharmaceuticals, Inc., 509 U.S. in 1993, the court serves as a gatekeeper to ensure that expert testimony is both reliable and relevant. Now, to see how many other times that this person has been testifying in court is a little bit bothersome, right? Whether they went all the way and was able to testify in trial, or whether he just brought forth expert testimony in those, as far as, just his expert testimony in writing is concerned, without it going to trial. It's very interesting to me, but I'm still going to be attempting to get this excluded out, right? Because of just the bias, prejudice. The court must assess whether, number one, the expert's scientific, technical, or other specialized knowledge will help the trier of fact. 2, the testimony is based on sufficient facts or data. 3, the testimony is the product of reliable principles and methods. And 4, the expert has reliably applied the principles and methods to the facts of the case. 2, Ovens' opinions are not the product of reliable methodology. Thomas Ovens is a retired law enforcement officer who has published blog posts and self-published materials on police practices. His opinions in this case are not the product of any peer-reviewed methodology. He does not cite a single published peer-reviewed study in support of his opinions. His methodology consists entirely of reviewing the body camera footage and applying his own subjective judgment, the type of espèce dixit reasoning that courts have repeatedly found insufficient to satisfy Daubert. See, Kumhotar, reliability inquiry applies to all expert testimony, including experience-based testimony. Nothing in either Daubert or the federal rules of evidence requires a district court to admit opinion evidence that is connected to existing data only by the ipse dixit of the expert, unquote. I'm going to have to pause for a second. I got to go to the restroom, bro. No cap. All right. So we got through on that one, which is, again, product of reliable methodology. And then Ovens failed to account for plaintiff's disability in his professional recommendations, right? Ovens' opinions invade the province of the jury. Ovens has a profound bias in favor of law enforcement. Of course, he's pro-law enforcement. He is law enforcement. It's been such his whole life. And then he misapplies constitutional law. Ovens opines that Schomborn's training supports the reasonableness of his conduct. Okay, but this opinion is constitutionally irrelevant. The Fourth Amendment's objective reasonableness standard is not satisfied by reference to departmental training. Okay, it doesn't. We don't care. Okay, your training is wrong. Officers are individually responsible for knowing and abiding by clearly established constitutional law. Harlow versus Fitzgerald in 1982. Training that lacks constitutional basis does not insulate an officer from liability. It compounds the violation by demonstrating systematic indifference to constitutional requirements. It's exactly the whole point I was trying to make, is that homeboys out here violating. Plaintiff's 14th Amendment equal protection rights were violated, okay? Disability, going into that. Plaintiff is entitled to punitive damages. In the alternative, the court should defer ruling pursuant to Federal Rule of Civil Procedure 56D, Rule 56D, if the court determines that plaintiff has not presented sufficient evidence to defeat summary judgment on any claim. Plaintiff respectfully requests that this court defer ruling on the motion pursuant to Federal Rule 56D as detailed in plaintiff's concurrently filed 56D declaration. Plaintiff has been unable to conduct essential depositions of the defendants due to indigency and severe physical incapacitation resulting from catastrophic motorcycle accident on May 17th. These depositions are essential to establish the officer's subject knowledge of plaintiff's disability and manifestations, B, the officer's retaliatory animus for plaintiff's recording and speech, C, the precise sequence of events leading to the use of force, D, the officer's training or lack thereof on ADA compliance during arrests, and E, the basis for the failure to identify charge when no traffic infraction had occurred. Summary judgment is premature, most definitely is, where the non-moving party, has not had a meaningful opportunity to conduct essential discovery. Then we're pretty much asking that the motion for summary judgment, be denied to exclude the testimony of Ovens to find general disputes of material fact and deny their claim of qualified immunity and set the matter for trial. Now they're going to respond to this, and we'll probably go back and forth a couple times. The reason I am saying that is based on my experience coming from Hood River. When Hood River filed for a summary judgment, we went back and forth for a couple times until the judge said, you know what, she's gonna stop and then she's gonna make a determination on things. So where we currently are with Washington State Patrol is that I just filed this. When did I file it? Well, I think I literally just filed this bad boy. Yeah, on the 6th. So on the 6th of May, we just filed this, and we're going to be waiting to get a response back from I think it's with the magistrate judge right now. I don't think it's with the federal judge right now. I think it's with the magistrate. And we'll get a response back from the magistrate judge, or we'll keep going back and forth for a little bit against Trooper Schomburn and Sergeant Hovinghoff until we can get a response or factual findings or a recommendation for the federal judge or federal district judge to be sent over. But we'll go back and forth, and we'll do our sir replies and our replies until the judge says no more, stop, and then makes a recommendation as the magistrate sends it up to the federal judge for the recommendation as far as how they see where it should go from here. And so we do have our opposition to the motion of summary judgment here with Washington State Patrol. So I wanted to update y'all with that. If y'all are wanting to get more details, you can always go to WSP under we got civil cases in the Discord. So if you go to civil cases, CAM WSP, civil suit, you can go in there and literally download pretty much everything. The requests for admissions, the disclosures, the plaintiff interrogatories, all of their responses, the motion for summary judgment, or you can go get it on the the docket if you'd like as well. But yeah, we've got pretty much everything in here, and you can review exactly where we're at this point right now, including the declaration that was filed. Any questions on WSP right now in its current position or state? No questions. Cool. All right, gotcha. Y'all being quiet on that one, not a problem.
I would think the younger generation would say they're cooked.
Yeah, man. Well, we would hope so. We're gonna hope so. And that the judges are starting to see, in favor of what's true, right? I'm the non-moving party, so yeah, hopefully they start doing right. But one thing I guess we need to go through and just kind of some preparation, and some people would say this is, oh, look at what's happening, or a bad thing, how they will always talk down or do whatever they need to do as far as the naysayers and the haters. We currently also have summary judgment that was filed by Hood River, and this was after doing the depositions. And let me see, I want to come over here and see where she's at. So in the Hood River, what we have also in this civil suit is, I think it's pretty funny, but I think it's just a test as well. But the judge, which is just the magistrate judge, for the declaration for the Hood River, and for the filing of the summary judgment, she went ahead and went along with the the defendants in the Hood River situation, and I find it pretty funny because judge recommendation, I guess it's already here, but I'll just save it in here anyways. She erred pretty heavily, and I think it's pretty embarrassing that I have to come through and push against the findings and recommendations made by Judge Russo. I find it pretty bad that this magistrate judge made the decisions like she made the decisions, because I have to object to them, and it's just not good because the objections that I'm making are pretty obvious. I think everybody knows when they look at this case, especially looking at the record, what the situation is. And to have it to where she's not in alignment with what has happened, I think I don't want to be rude, but it kind of makes her look bad because she's not bringing forth the facts as they currently are, right? So if we're looking at the situation, I guess we could just do it like this. We'll do this one first.
Don't bring the vehicle.
Oh, never mind.
My name is Emmy. I don't like the officer portion because then the officer portion makes it seem like I'm above you, which I am not. My name is Emmy.
What am I being arrested for?
You're being detained at this time.
Valley Trans that could possibly clear the air on how to move forward regarding this. We're going to include the original channel link as well as the original video that was edited by Brian at Here's the
Power inherent in the people. All power.
Obstruction. I want you in the front of your vehicle where you are.
My good sir, I've requested a...
And I'm going to detain you for obstruction. So, your decision. Yes, sir. It's obstruction. Sir, I'm going to give you 1 second to walk back down this way with me, and if you choose not to, I'm going to put you in handcuffs, and I'm going to detain you for obstruction.
Okay, so there's no mention of VIN. There's no traffic stop. They actually made a traffic stop on someone who was speeding. I was not speeding. I parked my car and I got out to do a walk before I got to my appointment, as I always do. But when I drive long distances, just so I stretch my leg and I'm not limping as I'm walking up to anyone's house, because I am an amputee. So I need to kind of build up that little pain restriction there and not limp. And so that's the reason, and I always do it when I'm driving or traveling long distances. And so the first statements that was made by Officer Imalike was that you need to come down to the vehicle with me. If you don't, I'm going to arrest you for obstruction. So obstruction of justice, to be honest.
So, your decision, yes, sir. It's obstruction. I want you in the front of your vehicle where you are.
My good sir, I've requested a sergeant, and
No sergeant's on here.
I have not committed any crime.
You have, because it's called obstruction right now. Your vehicle does not have plates.
Obstruction of what?
Obstruction of justice.
How am I stopping you from doing this?
Because I need you in the front of your vehicle so you can go ahead and grab all the information I will need from your vehicle. Your vehicle has plates that says not for hire. There's no sergeant available.
Okay, so nobody's ever asked me for my ID. Nobody's ever asked me for my name. There's no covering of the VIN charge being quoted. It's literally just obstruction, because he's going to need the information from me, right? So what we end up having is the judge. Now we've gone back and forth, okay? Me and the defendants, Hood River, have gone back and forth for quite a while, right? And we go back with a reply. I go with a reply. They go with a reply. When I get a reply, they get a reply. And it finally gets to like 2 or 3 replies of us arguing back and forth. And the judge says, all right, that's enough, right? And says that she's going to give her opinion. And so this is the opinion that she gives, right? Is that plaintiff was stopped after defendant police officers observed him driving a vehicle without registration plates, okay? While officers were speaking to the driver of she already claims that I was stopped after they observed me driving without registration plates. While officers were speaking to the driver of another vehicle stopped at the same time, plaintiff exited his vehicle and attempted to walk away from the scene of the traffic stop. Well, I was not a traffic stop. So, again, she's saying exited his vehicle and attempted to walk away from the scene. I didn't know there was a scene. I wasn't trying to attempt to walk away from a scene. I didn't know there was a scene. I wasn't walking away from a traffic stop. That was not my traffic stop. It didn't involve me at all. Officer Delancey observed a piece of paper that appeared to have been placed over the vehicle's VIN number. Not sure when that was, but when defendant officers informed plaintiff he was being detained as part of a traffic stop and asked him to return to his vehicle, plaintiff refused and asked to speak to a sergeant. Why would I return back to my vehicle when I wasn't stopped in my vehicle, right? I don't see how they could make me return to my vehicle if I wasn't stopped in my vehicle. That's not legitimate. Plaintiff was informed that a sergeant was not available and that if he failed to do as instructed, he would be placed in handcuffs. What do you mean, return down to my vehicle? I would be placed in handcuffs because I don't want to, because you're telling me to walk back down to my vehicle when I'm not at my vehicle no more? It's kind of weird to me. There's no crime. Plaintiff ignored Officer Delancey's instruction. I didn't ignore, but I did ask questions and badge numbers. So again, they're saying that I ignored Officer Delancey's instructions and asked again for a sergeant. Plaintiff also asked the officers of the badge numbers of the officers which the officers provided. All officers did not provide. So again, Judge Russo's conclusions and factual findings are incorrect because only 2 of the 3 officers actually provided their information. So the officers did not provide all of their information because Ryan Junt didn't even have an opportunity to, Judge Russo. So that is incorrect. The officers did not provide all of their info at that point. Plaintiff recorded the interaction on his cell phone. Plaintiff was again told that the sergeant was not available, not after this. That's not true. I was placed in handcuffs and was then placed in handcuffs and walked back to his vehicle so that officers could proceed checking his registration and license. So you'll notice that the judge is not mentioning that I was placed under arrest for obstruction of justice, which is not even a valid charge whatsoever. There's no charge in Oregon as far as obstruction of justice, but that's what I was arrested for. That's what was stated. And the judge doesn't even mention it at all. Does not mention that I was arrested falsely on a charge that doesn't exist. Makes no mention of it. Not at all. Not one bit. During the handcuffing process, Plainly was fully cooperative. Officer Delancey removed plaintiff's phone during the handcuffing process to ensure he did not stop the recording. So she acquiesced to their statements, but my phone literally went off. My phone went off when dude took the phone from me. So he did stop my recording. He placed the phone in plaintiff's pocket and advised plaintiff that he was not turning off the phone so that he could continue recording the encounter, but that was not the case. The officers determined the plaintiff did not have a valid driving privileges, no driver's license, that his vehicle registration expired in 2021, and that the vehicle lacked liability insurance. Plaintiff argued that valid driver's license was not necessary because he was not operating his vehicle in a commercial capacity, and that he did not need valid liability insurance. Plaintiff then requested to be free from handcuffs, which Officer Delancey obliged. Plaintiff was in handcuffs for approximately 7 minutes. Officer Delancey again advised that plaintiff's cell phone was in his jacket pocket. He could take it out to continue recording.
Hey,
Plaintiff
put my phone on the charger, please. It went dead. The one from last night.
Plaintiff replied, "Nah, it's all right," which I did. Right? There's nothing, because I knew that their body cameras were on. I don't need to record no more after I know that y'all's body cameras are on and you've already violated me. Why would I pull it back out? There's no point. I've already did the violation. After obtaining the vehicle's VIN number and verifying the vehicle had not been reported stolen, Officer Delancey released plaintiff with warnings as to all infractions. Plaintiff now brings unlawful arrest and all the rest, right? Summary judgment is appropriate if the pleadings, depositions, interrogatories, affidavits, and omissions on file, if any, show that there is no genuine dispute as the material fact, and the moving party is entitled to summary judgment as a matter of law. Some sense of law on an issue determines the materiality of fact. Whether the evidence is such that a reasonable jury could return a verdict for the non-moving party determines the authenticity of the dispute. The moving party has the burden of establishing the absence of a genuine issue of material fact. If the moving party shows the absence of a genuine issue of material fact, the non-moving party must go on beyond the pleadings and identify the facts which show a genuine issue for trial. Special rules of construction apply when evaluating the summary motion judgment. All reasonable doubts as to the existence of genuine issues of material fact should be resolved against the moving party, and the inferences be drawn on the underlying facts to be viewed in the light most favorable to the non-moving party. She's not even moving in my regards. Now, I'm the non-moving party. You're supposed to be ruling in favor of me, like what is best looked upon in the light of me. Well, she's just taking everything as the sir reply, and not even, she's saying she's gone through it, but she ain't ruling nothing in my favor. She's saying she reviewed the body camera footage, but she's agreeing with them, and then not mentioning the fact that they arrested me for a charge that doesn't exist, even after they have stated that it was not a traffic stop and that it was a consensual encounter, right? So these are very interesting claims coming from the recommendation here. For the foregoing reasons, the defendant's motion to summary judgment should be granted in this case dismissed. Wow, very interesting. Okay. It didn't get dismissed from before, but now it's getting dismissed. Okay. This recommendation is not an order that is immediately appealable, right? But we're taking it up to the federal judge to see what's going down. So we're about to bring our objections. And so the objections in the memorandum that we are bringing is as follows. Okay, plaintiff's objections to the magistrate judge's Russo's findings and recommendation. Now we've gone back and forth again, like I've said, in relation to the summary judgment. Now the judge is the lower magistrate judge, because it's not with the federal judge, has made a factual finding and recommendation to the higher judge, and we're about to defeat these findings and recommendation to the higher judge. And the way that we do that is through the objections to the magistrate judge's recommendation. And you have to be thorough. Okay, you have to be very thorough. So we have quite a few objections in relation to it. And I want to go through a couple, but I also want to go through a memorandum that is supporting, and which is very recent in relation to a 6-judge panel as far as what's being decided on qualified immunity and how recent it is and how important it is and how it ties in. Let's see. The FNR recommends granting defendant's motion for summary judgment in its entirety and dismissing this action. And reaching this recommendation, the magistrate judge concluded that there is no contradiction of defendant's facts by the evidence in the record. This conclusion is not merely erroneous, it is demonstrably and irreconcilably false when measured against the sworn deposition testimony of the defendant officers themselves and the verbatim transcript of the body-worn camera footage. The FNR commits to the precise constitutional error condemned by the Supreme Court in Tolan versus Cotton. It resolves genuine disputes of material fact in favor of the moving party, credits defendants' post hoc rationalizations over real-time evidence, and ignores the non-moving party's evidence entirely. The magistrate judge's analysis is infected by three fundamental errors that permeate the entire recommendation. First, the FNR completely omits the actual stated basis for plaintiff's arrest. Obstruction of justice, a charge that defendant Delancey admitted under oath does not exist as a statute or code in Oregon. Instead, the FNR adopts defendant's post hoc rationalization, the covered VIN, as the undisputed basis for detention, despite the transcript proving the VIN was not mentioned until after plaintiff was already in handcuffs. Second, the FNR characterizes the encounter as a traffic stop of plaintiff, when the undisputed evidence, including defendant Delancey's own sworn testimony, establishes that officers stopped a different vehicle for speeding, that plaintiff was already parked and not operating his vehicle, and that the encounter was not a traffic stop in the traditional sense. Was not the traffic stop in a traditional sense. Verbatim, coming from them. Okay. Third, the FNR ignores the officer's own admissions that the plaintiff was never asked for his identification prior to being handcuffed. That plaintiff was cordial throughout the encounter. That's what they're stating, not me. And that asking for badge numbers does not constitute obstruction, and that no citations were issued for any offense. These are not minor discrepancies. They are genuine disputes of material fact that go to the heart of every constitutional claim in this action. So under the mandatory standard of Anderson versus Liberty Lobby, incorporated in 1986, and the heightened scrutiny required in Section 1983 cases under Tolan, summary judgment must be denied, whereas here, the evidence viewed in the light most favorable to the non-moving party creates genuine issues for trial. Plaintiff respectfully requests that this honorable court conduct a de novo review pursuant to and reject the FNR in its entirety, deny the defendant's motion for summary judgment, and set this matter for a jury trial, as is the creator endowed right of every citizen to have his claims heard by a jury of his peers. Okay? So again, de novo review is mandatory. We're bringing in the rules here. Okay? When a party timely objects to the magistrate judge's findings and recommendation, the district court shall make a de novo determination of those portions of the report or specified proposed findings or recommendations to which objection is made. Okay? Again, that's Federal Rules of Civil Procedure 72B3. Quote, the district judge must determine de novo any part of the magistrate judge's disposition that has been properly objected to. And I've got 28 different objections, so all of them is a de novo review. Okay, the district court, quote, may accept, reject, or modify in whole or in part the findings or recommendations made by the magistrate judge. Okay, de novo review is not a rubber stamp. It requires the district court to independently evaluate the evidence and legal conclusions, giving no deference to the magistrate judge's findings on disputed issues. Okay. This is particularly critical where, as here, the magistrate judge's factual findings are contradicted by the evidentiary record. Okay? Totally is. Got to get a de novo review. So I'm saying when we can get remedy, we get remedy. This ain't even the appeal part. This is just a de novo review, which we are entitled to. Okay? Summary judgment is only appropriate if, quote, there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. But guess what? There is a genuine dispute to a material fact. Plenty of them. So I don't see how we got to the summary judgment point. Supreme Court has established an unyielding framework for this analysis. A dispute is genuine if the evidence is such that a reasonable jury could return a verdict for the non-moving party. Quote, at the summary judgment stage, the judge's function is not himself to weigh the evidence and determine the truth of the matter, but to determine whether there is a genuine issue for trial. The court must view the evidence in light most favorable to the opposing party, me. All justifiable inferences must be drawn in favor of the non-moving party, me. Credibility determinations, the weighing of evidence, and the drawing of legitimate inferences from the facts are jury functions, not those of the judge. The non-moving party need not produce evidence in a form that would be admissible at trial in order to avoid summary judgment. Ding, 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 ding. Again, let's listen in. The non-moving party need not produce evidence in a form that would be admissible at trial in order to avoid summary judgment. Although I have, the question is whether the evidence viewed favorably to the non-movement, me, presents a sufficient disagreement to require submission to a jury. Thank you. Let's move this on. This has to move on out of the summary judgment because, again, I'm not the moving party. Okay, y'all gotta be in favor of me. Again, the heightened scrutiny in Section 1983 cases. This is coming out of Cotton, should I say? Quote. In holding that Cotton's actions did not violate clearly established law, the Fifth Circuit failed to view the evidence at summary judgment in light most favorable to Tolan with respect to the central facts of this case. By failing to credit evidence that contradicted some of its key factual conclusions, the court improperly weighs the evidence and resolved disputed issues in favor of the moving party. So you can see how it would be reversed. Okay? This is definitely applicable to my situation. That's what this judge has done. She's weighed the evidence and resolved disputed issues in favor of the moving party when it's actually supposed to be in favor of me. Okay? All right? The magistrate judge's F&R commits the exact error condemned by Tolan. Thank you. Okay? So the pro se liberal construction, we already know Haynes versus Kerner and how important that is. Then the magistrate judge's foundational error, the objectively falsity of the no contradiction finding and the cascading corruption of every legal conclusion in the findings and recommendation. And I don't like to be this way, but I have to be very precise in relation to the corruption, right? Because the legal conclusions it is corrupt. I mean, literally, you're taking on their post hoc rationalization. You've literally conceded that it was a traffic stop when clearly it wasn't. They clearly made a traffic stop on somebody else. They were sitting at a stop sign for 15 seconds before they even turned. So I had already been gone for 15 seconds, so there was definitely no stop on me. But the central false premise is that I find no contradiction of defendant's facts by the evidence in the record. Crazy. This statement is not a matter of competing inferences, reasonable disagreement, or judicial discretion. It is objectively, demonstrably, and irreconcilably false when measured against the sworn deposition testimony of the defendant officers themselves and the verbatim transcript of the body-worn camera footage. The defendant officers, under oath, subject to penalty of perjury, provided testimony that directly contradicts the factual narrative the magistrate judge adopted wholesale from defendant's briefing. Crazy, bro. Crazy. This error is not harmless. It is structural. Because the magistrate judge's no contradiction declaration is false, every legal conclusion that flows from it is built upon a false factual foundation. Everything. If you're going to base that on that, everything else is false. Well, we can't trust you or believe anything you have to say. Contradiction number one, the traffic stop. Mischaracterization, destroys reasonable suspicion under Terry and probable cause under Beck. Because the F&R findings are that the magistrate judge states that the plaintiff, Wilson, was stopped after the defendant police officers observed him driving a vehicle without registration plates. The contradiction. The body-worn camera transcript in the defendant Delancey's sworn testimony directly contradict this finding. The transcript establishes that officers were conducting a stop on a different vehicle, an SUV, that had been speeding. It was only after the defendant Delancey exited his patrol vehicle to approach that other vehicle that they noticed plaintiff's car already parked. Delancey's own words captured in real time where, quote, he don't have a plate on his car, so call him back, unquote. So for the judge to say that they noticed that I had plates, as she put it in the context of her factual findings, or the summary of facts, was that they noticed that I didn't have plates at first, right? And that they saw somebody else speeding, and so that they pulled that person over. Well, no, they pulled that other person over because they were speeding, and then when they got out the car to approach the vehicle, then they noticed that I didn't have plates. Okay? So don't put it in your statement of facts that they noticed that I didn't have plates first off, like they just already knew first. They didn't know until they got out for the other car. So let's make that very clear. Plaintiff was already parked. Plaintiff was not stopped. Plaintiff was not operating a moving vehicle. The officer did not initiate a traffic stop on plaintiff. Because under oath, defendant Delancey confirmed this sequence. Question, was Mr. Wilson operating his vehicle when you made contact? No. So this was actually not a traffic stop in the traditional sense, was it? No. Okay? Defendant Griffin further confirmed the consensual nature of this encounter in his own deposition. Why this contradiction is material. The distinction between a traffic stop and a consensual encounter is not semantic. It is constitutionally dispositive. It's the whole point. So she's already made a big-time error because she's trying to make it seem as though this was a true traffic stop when it was not whatsoever, okay? It was a consensual encounter, or should have been a consensual encounter. Why the summary judgment cannot be granted. Whether the encounter was a traffic stop or a consensual encounter is a genuine dispute of the material fact, okay? A reasonable jury, viewing the transcript of the officer's own admissions, could conclude that plaintiff had no legal obligation to comply with an officer's command, and that no reasonable suspicion existed to justify detention, and that the entire encounter was constitutionally infirm from its inception. This dispute alone precludes summary judgment. That right there should stop summary judgment. But we'll continue. Contradiction 2. The fabricated obstruction of justice. The FNR's finding is that the magistrate judge's FNR never once mentions the charge of obstruction of justice. She never mentioned it, not once. The word obstruction does not appear in the FNR's factual recitation. She don't even bring in the word obstruction in her factual findings. But that was literally the whole point of why I was arrested. I was arrested based on obstruction of justice. The FNR instead adopts the post hoc rationalization of a covered VIN as the basis for the detention and in the arrest. But the contradiction in the body camera is I'm detaining you for obstruction. This was contemporaneous stated basis for the arrest, not the VIN, not the plates, but obstruction. Under oath, defendant Delancey was confronted with this fact. Question: obstruction of justice is not a statute or code in Oregon, is it? No, it's not. Defendant Delancey arrested plaintiff for a crime that does not exist in the state of Oregon. He then admitted this under oath. Why this contradiction is material. This is not a peripheral disputed fact. This is the core of this entire case. Probable cause requires a reasonable belief that a person has committed an actual existing crime. An arrest predicated upon a charge that does not exist as a statute cannot, as a matter of law, be supported by probable cause. That is a disputed fact, Judge. I don't see how you could not see how it's not, and I see why you intentionally left out obstruction and any mention of that within your factual findings. I find it very disingenuous for you to do such as well. That's not fair, and I think it's, I think it's horrible. Why summary judgment cannot be granted. The magistrate's judge's entire qualified immunity analysis is built on the VIN rationalization, a justification that was never articulated at the moment of arrest. A reasonable jury hearing Delancey's real-time statement, I'm detaining you for obstruction, and his deposition admission, obstruction of justice is not a statute or code in Oregon, could find that the arrest was made without probable cause and that the VIN was a post hoc fabrication and that the arrest violated clearly established Fourth Amendment law. The omission of this central fact from the FNR is not a minor oversight. It is a structural error that voids the qualified immunity analysis entirely. Okay? So now are we starting to see how even though the judge may bring something like, oh, we're granting their summary judgment and qualified immunity should be granted. Do you see how honestly it's really not that strong? Right? We're looking at it now and it's kind of like, even though you might be disappointed that you get a summary judgment in being granted, right, or the recommendation being granted, or a recommendation in favor of the defendants, that don't mean nothing, bro. You just got to make sure that you're coming through properly for the higher judges, because this is just a magistrate judge, bro. So maybe it's a test to see, hey, can homie get through this? Is he going to give up? Is he going to suppress? Is he going to falter? Is he going to, or is he going to stand strong without getting so emotional and bring forth what needs to be brought forth to move everything forward? Sometimes these things are just tests. Contradiction 3, the VIN post hoc timeline violates the contemporaneous probable cause requirement. The FNR relies on the covered VIN as the legal basis for the plaintiff's detention. The contradiction is that the transcript establishes an unambiguous timeline. Plaintiff was handcuffed at page 4 of the transcript. The VIN was not mentioned until page 7 of the transcript. Plaintiff was already in handcuffs. The VIN was not the reason for the arrest. It was the reason offered after the arrest had already occurred. Why summary judgment cannot be granted. A reasonable jury reviewing the transcript page by page could find that the VIN was a post hoc rationalization designed to justify an arrest that was actually made for a non-existent charge. This creates a genuine dispute of material fact that precludes summary judgment. Again, things must be ruled in favor of me. I'm the non-moving party. So you're supposed to look at it in favor of me. You're supposed to look at it in my light. How I viewpoint it, you're supposed to be like, yeah, well, I guess if you could view it like this, then we'd move forward in favor of him. That's how you have to view it, Judge. You have to view it in favor of me, not in favor of them. This is my viewpoint. You have to look at it in favor of my viewpoint. Contradiction. The walked away mischaracterization creates a mandatory jury question under Neves, which is very crazy that the judge actually acquiesced to this as well. I think it's very, very weird that she did, but she did. The FNR's findings, the magistrate judge states that the plaintiff, quote, attempted to walk away from the scene. This characterization is used to justify the officer's escalation and the application of force. The contradiction, Officer Junt, under oath, provided the definitive account of what actually occurred. Quote, did Mr. Wilson turn to address you? Answer, I believe he did, yes. Was that threatening in any way? No. Plaintiff did not attempt to flee. Okay, I turned around to ask dude for his badge number. Plaintiff did not attempt to evade arrest. I didn't take steps away. So this plaintiff attempted to walk away from the scene is a complete lie, Judge, and you know so. For you to even characterize me turning around to ask Junt for his name and ID is insane to me and just shows. Plaintiff turned to ask Officer Junt, the third officer present, for his name and badge number. This is a protected First Amendment activity. Contradiction. Why this is material. The characterization of plaintiff's movement as walking away is used by the magistrate judge to justify both the arrest and force used. If plaintiff was actually turning to ask for a badge number, Officer Junt, which as Officer Junt admitted under oath, then the legal analysis changes entirely. Under the First Amendment retaliation framework of Neves versus Bartlett, a plaintiff can defeat qualified immunity by showing that officers took adverse action against him in direct response to his protected speech, and that the causal connection is established by the temporal proximity between the protected activity and the adverse action. Here, plaintiff was handcuffed within seconds of asking for a badge number. This is precisely the type of objective evidence that Neves contemplates as sufficient to create a jury question. Why summary judgment cannot be granted? Because whether plaintiff was walking away, which I was not, I took a step, I actually just turned around, or turning to ask for a badge number is a genuine dispute of a material fact. Again, whether plaintiff was walking away or turning to ask for a badge number is a genuine dispute of material fact. Okay? Officer Junt's sworn testimony directly contradicts the magistrate judge's characterization. A reasonable jury could find for plaintiff on this point, and that finding would require denial of qualified immunity on the First Amendment retaliation. Contradiction 5. The absence of any identification request before arrest destroys the legal basis for detention. The FR implies that plaintiff was uncooperative and refused to comply with lawful officer requests. Defendant Delancey admitted under oath that he never asked plaintiff for his name or identification before placing him in handcuffs. Did you ask Mr. Wilson for his name? No, I didn't. The transcript confirms that this. Plaintiff himself stated, you haven't given me a chance. Plaintiff was arrested before he was even given the opportunity to comply with any request. Why this contradiction is material. Even in a valid investigatory stop under Terry, an officer must first make a request before concluding that the person is being uncooperative. Brown versus Texas requiring that any demand for identification be reasonably related to the circumstances justifying the stop. What was justifying the stop? Obstruction of justice? That ain't even a real charge. So that don't fit. So if plaintiff was never asked for identification, he cannot be said to have refused to provide it. The entire premise of the obstruction charge collapses. A person cannot obstruct an investigation that has not yet been initiated by any lawful request. Why summary judgment cannot be granted? A reasonable jury, hearing Delancey's admission that he never asked for identification, could find that there was no lawful basis for the arrest, that plaintiff was never given an opportunity to comply, and that the arrest was therefore constitutionally infirm. This is a genuine dispute of material fact which precludes summary judgment. Contradiction 6, the badge number timing contradiction creates a jury question. Okay, what's next? The cumulative effect of the magistrate judge crossed the constitutional line. Each of the foregoing contradictions, standing alone, will be sufficient to preclude summary judgment. Taken together, they establish the magistrate judge's no contradiction declaration is not merely erroneous, but it is a wholesale abandonment of the summary judgment standard. The Supreme Court's instruction in Tolan versus Cotton could not be made more directly applicable. Okay? By failing to credit evidence that contradicted some of its key factual conclusions, the court improperly weighed the evidence and resolved disputed issues in favor of the moving party. The magistrate judge's F&R commits this exact error. She cited defendant's post hoc rationalization, the VIN, the traffic stop, while ignoring the officer's own real-time statements, I'm detaining you for obstruction, and their own sworn deposition admissions. Obstruction of justice is not a statute or code in Oregon. She characterized plaintiff's movements as walking away, while ignoring Officer Junt's sworn testimony that plaintiff was turning to ask for a badge number, and that this was non-threatening. She implied plaintiff was uncooperative, while ignoring Delancey's admission that he never even asked for identification. The Constitution and the federal rules of civil procedure are clear. The judge's task at summary judgment is not to decide which version of the facts is true, okay, but only to determine whether a reasonable jury could find for the non-moving party. You hear me? Let's hear this again. The judge's task at summary judgment is not to decide which version of the facts is true. It's not what she's supposed to do, but only to determine whether a reasonable jury could find for the non-moving party. Me. Anderson, 477 U.S. at 249.50. In this case, a reasonable jury could and should find for plaintiff on every claim. The magistrate judge crossed the constitutional line by making that determination herself. This court must correct that error by rejecting the F&R, denying summary judgment, and setting this matter for jury trial. Statement of genuine disputes of material fact. Okay? Subject, the traffic stop. The plaintiff was stopped after officers observed him driving without plates. Okay? Contradicting evidence. Officer stopped a different vehicle for speeding. Plaintiff was already parked. Delancey stated, not a traffic stop in the traditional sense. Okay? The fabricated charge admits the actual basis for arrest, which is obstruction for justice. The VIN timeline relies on covered VIN as the basis for detention. Okay? Then we're coming in for the plaintiff's movement. Plaintiff attempted to walk away from the scene. That's what the judge is stating now. F&R finding. Okay. Plaintiff turned as a junt to ask for badge number. Junt. I believe he did. Yes. Request was non-threatening. See. Identification implies plaintiff refused to cooperate. That's what the F&R finding is. Okay. Contradicting evidence. Did you ask Mr. Wilson for his name? No, I didn't. The subject. Order versus request. Officers asked plaintiff to return. Delancey, no, I didn't ask. I said you're going to come back down to your vehicle. Okay, and it was not polite. Badge numbers. Officers, again, this judge is stating, officers provided badge numbers. Plaintiff arrested while asking Junt. Junt was prepared, but never provided before arrest. Exactly why, again, she's over here giving false statements in hers. That's not my fault. You better get what you make your statements accurate, because Junt never provided his badge number. Okay, ever. Okay. Phone seizure. Phone placed in pocket to ensure he did not stop the recording. Well, the recording did stop after seizure. Jury could find seizure was retaliatory. Plaintiff was fully cooperative. Okay. If cooperative, arrest for obstruction is baseless. Okay. Delancey stated, and you've been cordial. Released with warnings as to all infractions. Okay. Delancey, I'm not going to issue you a citation for anything. Well, there's 0 citations were issued. Okay. It's contradicting evidence. The subject here, retaliation, no evidence of casual connection. Handcuffed seconds after asking Junt for badge number. All officers admit badge numbers are not obstruction. Prosthetic leg, limb. Plaintiff never mentioned prosthetic. Prosthetic is visible. Verbal mention not required to trigger duty of care. It's a jury question. Equal protection. Plaintiff was only individual who attempted to get out. Plaintiff was already outside vehicle when officers arrived. Did not get out during a stop. Qualified immunity. Officers did not violate clearly established law. Arresting for a non-existent crime, obstruction of justice in Oregon, violates clearly established Fourth Amendment law. Okay? It's very simple. It doesn't, I don't know what y'all talking about. Officers did not violate clearly established law. Bro, obstruction of justice in Oregon don't even exist. So clearly they violated Fourth Amendment law. They arrested me on a charge that didn't even exist. I'm so confused. Judge, magistrate. So specific objections to the factual findings. Objection 1, the magistrate judge erred in finding plaintiff was subject to a traffic stop. Okay, so what we got going on is in the traffic stop, when defendant Delancey exited his patrol car for that other stop, he noticed plaintiff's vehicle was already parked. Okay, Imalike, he don't have a plate on his car, so call him back. Call him back. We saw you on the roadway. You parked. That doesn't mean we can't talk to you. Deposition evidence. The defendant Delancey admitted under oath that the plaintiff was not operating his vehicle and that this was not a traditional stop. Again, Mr. Wilson, was Mr. Wilson operating his vehicle when you made contact? No. So this was actually not a traffic stop in the traditional sense, was it? No. Okay? So the legal analysis that the magistrate judge is finding that the plaintiff was stopped after officers observed him driving is directly contradicted by the officer's own admissions. Plaintiff was already parked. Okay? Okay? A reasonable jury could find that the officers lacked reasonable suspicion to initiate a Terry stop plaintiff who was merely parked in a public space. Objection 2. The judge erred in the obstruction of justice charge. Okay? She didn't mention it at all. The transcript provides that it was for, again, the VIN. I'm not going to put you in, I'm going to put you in handcuffs. I am going to put you in handcuffs and I'm going to detain you for obstruction. Obstruction? Yes, it's obstruction. Obstruction of what? Obstruction of justice. Okay? Not a VIN. Not a VIN. Obstruction of justice. Okay? Obstruction of justice is not a valid charge in Oregon in that he was never charged anyone with exercising constitutional rights. Question. Obstruction of justice is not even a statute or a code to be applied in Oregon. No. You can't arrest someone for obstruction of justice in Oregon. Admitted. Can requesting badge numbers constitute obstruction of justice? No. Okay? Delancey. That's Delancey. So, this is the most egregious error in the FNR. The magistrate judge completely ignored the actual stated basis for plaintiff's arrest, a charge that the arresting officer admits does not exist in Oregon. So an arrest for a non-existent crime is per se a violation of the Fourth Amendment. That's why she didn't mention it whatsoever. Straight ignored it. No mention whatsoever. Probable cause requires an actual criminal offense. So by admitting this fabricated charge, the FNR improperly shielded defendants from liability for an unconstitutional arrest. It's clear. That's what she did. And why it cannot survive. Objection 3, the magistrate erred in adopting the post hoc VIN rationalization instead. The transcript proves the VIN was not mentioned until after plaintiff was already in handcuffs. There's no sergeant available, sir. So here's what we have. The VIN is covered up. The deposition evidence. The defendant Delancey attempted to use the VIN as a post hoc rational justification for the detention during his deposition. What was the reasoning for detaining Mr. Wilson? Mr. Wilson had his vehicle VIN covered. So the legal analysis. The FNR adopts defendant's post hoc rationalization, the VIN, while ignoring the real-time evidence, the fabricated obstruction charge. The Supreme Court has repeatedly held that an arrest must be justified by the facts known to the officer at the moment of the arrest. Beck versus Ohio in 1964. Facts discovered after the arrest, such as a covered VIN, cannot retroactively establish probable cause. The magistrate judge's reliance on the post hoc VIN rationale is a reversible error. What's up, Doug?
Oh, I was just about to say he arrested you in order for you to incriminate yourself.
Correct.
That's the obstruction charge.
Correct. And he even read me my Miranda while reading it. So even if I said, I'm going to remain silent at that point, what could he have really, really, truly done? But of course, I let him dig a hole. Objection 4, the magistrate judge erred in finding plaintiff attempted to walk away. your name and badge number, please. Asking third officer, sir. Okay, that's fine. You're going to be detained now. Officer Junt wasn't even able to give it to him. He just immediately arrested me. Defendant Junt confirmed plaintiff asked for his badge number and that the request was not threatening. Yep, we already did that. So the FNR mischaracterizes plaintiff's protected First Amendment activity asking for a badge number as an attempt to walk away or flee. A reasonable jury could find that plaintiff was merely turning to address the third officer, not attempting to evade detention. The magistrate judge's failure to draw this legitimate inference in plaintiff's favor violates the summary judgment standard. So do you understand that? So I'm stating that I turned to ask the third officer and was not attempting to flee or walk away. The judge did not find, right? The magistrate judge failed to draw this legitimate inference in my favor. That violates summary judgment standard. Do you see how this summary judgment can't survive? Do y'all understand? So even though we're seeing that this judge moved forward, all of these errors are what's going to end up getting this summary judgment reversed. And it's not going to be able to survive, which is a really good thing for me. And I wish she would have just been like, no, like I have to rule in favor of the defendant already. That would have been even better. But I guess me kind of beating up her error is pretty cool too. Like I'm guessing it's like a test. It's like, hey, we're testing you. We're going to see where you're at, see how strong you are, see if you can come through and present yourself without being too emotional, and what you're going to utilize to stand on that. Objection 5. The magistrate judge erred in finding plaintiff was asked for identification before arrest. The FNR implies plaintiff was asked to cooperate and refused, leading to his detention. Plaintiff explicitly stated he was never given a chance to provide identification before being handcuffed. Cameron, it's my car, but you haven't even given me a chance. You've put me in handcuffs. The deposition evidence. Defendant Delancey admitted under oath that he never asked plaintiff for his name or identification before being arrested. Did you ask Mr. Wilson for his name? No, I didn't. Not at that point. Did you ask Mr. Wilson why he didn't just have plates on his vehicle? At that point, I did not. The FNR's narrative that plaintiff was uncooperative is destroyed by Delancey's own admission that he never even asked plaintiff for his name before handcuffing him. An individual cannot obstruct justice by failing to provide identification if he has never asked for it. Browns versus Texas. The magistrate judge's failure to credit this devastating admission is reversible error. Objection 6. The magistrate judge erred in finding officers asked plaintiff to return. The FNR states that the officers asked plaintiff to return to his vehicle. The plaintiff transcript proves plaintiff was not asked. He was ordered under threat of arrest. Imalike, okay, sir, I'm giving you, and this is the first thing that Imalike ever stated to me, y'all. Okay, sir, I'm giving you 1 second to walk back down with me this way. If you choose not to, I am going to put you in handcuffs, and I'm going to detain you for obstruction. The defendant Delancey admitted under oath that he did not ask plaintiff and that he was not polite. Question, did you ask Mr. Wilson, can you come back down to your vehicle with us? No, I didn't ask. I said, you're going to come back down to your vehicle. Did you request Mr. Wilson come back down to the vehicle in a polite manner? No, I didn't say it in a polite manner. Legal analysis. The distinction between a consensual request and a coercive order is fundamental to a Fourth Amendment jurisprudence. By characterizing a threat of arrest as a mere request, the FNR improperly sanitizes the coercive nature of the encounter and resolves a disputed fact in defendant's favor. Again, this magistrate judge keeps bringing forth these disputed facts in the moving party's favor rather than the non-moving party. That's not accurate to summary judgment standards, y'all. Again, things that we have to stand on and recognize. Hopefully by going through all these are giving you some element of comprehension of what you may combat or come up to and how to combat it by every single possible way. The magistrate judge erred in finding officers provided badge numbers. Plaintiff also asked the officers for their names and badge numbers, which the officers provided. See how I'm attacking even this one? The transcript proves plaintiff was arrested while asking the third officer for his badge number. Your name and badge number, please. Asking third, sir. Okay, that's fine. You're going to be detained now. The deposition evidence. Defendant Junt admitted that he never provided his badge number before the arrest occurs. Were you prepared to provide your name and badge number to Mr. Wilson? I was, but he never did. Okay. And that's in the deposition. Legal analysis. The FNR's findings that the officers provided their badge numbers is factually incomplete and misleading. Plaintiff was arrested precisely at the moment he asked defendant Junt for his badge number. And this is how I know she didn't really truly review everything. She just acquiesced to their damn declarations and didn't really truly review everything, because if she did, she wouldn't be putting statements like this in her factual findings. She wouldn't be making obvious mistakes as though they provided their badge numbers, because they didn't. This right here is literally reversible just based on this one thing. She literally said they provided their badge numbers when on the record they didn't. So like that's how I know it's going to survive. She's completely wrong. So plaintiff was arrested precisely at the moment he asked defendant Junt for his badge number. This temporal proximity is the crutch of plaintiff's First Amendment retaliation claim. Objection 8. The magistrate judge erred in her characterization of the phone seizure. We don't have to go through that one. The judge erred in finding plaintiff was fully cooperative while simultaneously justifying his arrest. During the handcuffing process, plaintiff was fully cooperative. The transcript proves plaintiff was cooperative, cordial, and provided all requested information. And because it's Emileke, and you've been cordial, that's why I'm not issuing anything. I've been cordial, right? Yeah, I'm not going to give you a citation. Defendant Junt confirmed plaintiff was not rude or threatening. Deposition evidence. Did you view Mr. Wilson's request for badge number as threatening? No. Legal analysis. The FNR contains an irreconcilable internal contradiction. If plaintiff was fully cooperative and cordial, as the officers admit, then the arrest for obstruction of justice is demonstrably baseless. Objection 10. The magistrate judge erred in finding no evidence of First Amendment retaliation. Okay. The deposition of evidence. All three officers admitted that asking for badge number is First Amendment protected activity and does not constitute obstruction. Question. Do you understand that asking for badge numbers is protected First Amendment activity? Sure. Is asking for badge numbers a form of obstruction of justice? Not necessarily. Legal analysis. The FNR's conclusion that there is no evidence of a causal connection ignores the temporal proximity of the events. The Ninth Circuit has repeatedly held that timing can properly be considered as circumstantial evidence of a retaliatory intent. Arresting a citizen immediately after he engages in protected speech, asking for badge number, creates a triable issue of fact regarding retaliatory motive. Objective 11. The magistrate judge erred in finding no Fourth Amendment violation. Okay, the FNR concludes that the defendants had reasonable suspicion to detain plaintiff and probable cause to arrest him based on the covered VIN. But the transcript proves that the stated basis for the arrest was obstruction of justice, not the VIN. No wonder why she ignores it. Emily K., I'm going to put you in handcuffs. I'm going to detain you for obstruction. The defendant Delancey admitted under oath that obstruction of justice is not a valid charge. So, the FNR's Fourth Amendment analysis is fundamentally flawed because it relies entirely on the post hoc rationalization of the VIN while ignoring the factual fabricated charge of obstruction of justice. An arrest for a non-existent crime violates the Fourth Amendment. The magistrate judge's failure to analyze the actual basis for the arrest is a reversible error. The magistrate judge erred in finding no excessive force. They shouldn't arrest me at all, and I was cordial, right? What else we have? The judge erred in finding no equal protection violation. We saw that you were on the roadway, you parked. That doesn't mean we can't talk to you. Defendant Delancey admitted plaintiff was not operating his vehicle. Was Mr. Wilson operating his vehicle when you made contact? No. Legal analysis, the FNR's factual premise for dismissing the equal protection claim is false. Plaintiff did not attempt to get out during a traffic stop. He was already parked and outside his vehicle. The officers targeted him while ignoring other parked vehicles. This desperate treatment of class of 1 violates the equal protection clause. Objection 14. The magistrate judge erred in granting qualified immunity. Obstruction of justice is not a valid charge. It's crazy. Objection 15. The magistrate judge erred in dismissing the Monell claim. Objection 16. The magistrate judge erred in ignoring the Miranda implications. 17. The magistrate judge erred in ignoring the fruit of the poisonous tree doctrine. Objection 18. The magistrate judge erred in dismissing bystander liability. Objection 19. The judge erred in failing to consider the totality of the circumstances. And then the conclusion and prayer for relief, right, where we're asking that they conduct a de novo review of the magistrate judge findings and recommended pursuit, reject the factual findings and recommendations, and deny the defendant's motion for summary judgment. Okay? And so that's how we're moving in both of the suits right now. Okay? So we've got objections for 1. Now, what's going in support of this objections is what I think I've kind of mentioned before, which I want to make sure that y'all are aware of, which is the new case. And plaintiff's supplemental memorandum of law to support of objections of 2 findings and recommendations. Okay. The doctrine of qualified immunity as applied by Magistrate Judge Jolie Russo in the factual findings rests upon the legal foundation that has now been definitively and irrevocably shattered by the Supreme Court of the United States. On April 22nd, 2026, less than 6 weeks after the magistrate judge issued her findings and recommendations, the Supreme Court issued its opinion in Hensley versus Fleur Corp., authored by Justice Clarence Thomas and joined by a 6-justice majority comprising the others. That opinion articulates 5 governing principles regarding judge-made defenses that, when applied to the undisputed record in this matter, categorically and irrevocably preclude the application of qualified immunity to Officer Emelike Delancey. Now, why am I trying to bring this? Why am I bringing this in? Is because I'm trying to defeat qualified immunity in some form. Do I already believe that I have the summary judgment beat by the standard in and of itself? Yes. But if I can come in and try and get something applied under qualified immunity and see if the federal judges can also agree with me on this point as well, that might look really good later on down the line, or just look good, period, right? And that's why I want to bring it in. So this is not a closed question. Officer Delancey arrested plaintiff Mr. Wilson, James Wilson, for obstruction of justice, right? A charge that Delancey himself admitted under oath does not exist as a statute in the state of Oregon. No law, no policy, no directive, and no authorization from the city of Hood River or any governmental authority directed, requested, or sanctioned Delancey to fabricate a non-existent criminal charge to effectuate a retaliatory arrest of a man who was doing nothing more than exercising his First Amendment right to ask for badge numbers. They literally got to understand. If it was necessary for him to do everything that he did, then why didn't he issue out a citation? Why were there no citations ever issued? Right? So I think that's a real big deal here. So under Hensley's 5 principles,
he was even saying in that video though that if this was all true, that he's going to get rid of his license too and do what you're doing. I remember watching that video.
Oh, well, he made statements saying, "Oh, well, if it's true,
yeah, I'm gonna do it too."
And then
I'm not paying him.
And then went on later to say it is true. Oh, you do have the right to travel.
I think when you started asking for badge numbers, Delancey had kind of an idea that you may know what you're trying to do, and that's why he attempted to put a stop to it. And then once he figured out that you really know what you're talking about, he took them handcuffs off and started, playing the game with you. And that judge is doing the same thing. They're just trying to see how much you know.
Yeah. Yep. They're trying to see how far I can get it. I think it's a test for sure.
Yeah, being tested.
No law, no policy, no directive, no authorization from the city. Yep. Okay. So under Hensley's 5 principles, okay, and this is the new case. I want y'all to really recognize this. Again, it is Hensley versus Fleur Corp. Okay. Number 24-924 U.S. April 2022, 2026. Okay. So under Hensley's 5 principles, judge-made defenses protect only conduct the government actually authorized. Okay. The government never authorized the fabrication of a crime. Where there is a right, there is a remedy. The remedy here is a jury trial. Furthermore, as established by the exhaustive historical scholarship of Professor Alexander Reinert of Cardoso School of Law, the version of 42 U.S.C. section 1983 upon which the magistrate judge relied is itself a corrupted text, a statute from which a critical notwithstanding clause expressly enacted by the 42nd Congress in 1871 was erroneously omitted by the Reviser of Federal Statutes in 1874. That omitted clause explicitly abrogated all state law immunities and customs. The magistrate judge granted immunity based on a doctrine that Congress itself prohibited in the original statute. The court must correct that error. This supplemental memorandum of law is supported pursuant to 28 U.S.C. section 636B1C and Federal Rule of Civil Procedure 72B2 and is timely filed within the extended deadline of May 11, 2026 as ordered by this court, ECF number 56. And plaintiff respectfully requests that this court treat this memorandum as supplemental authority to his objections and apply the controlling principles of Hensley versus Floor Corp to deny qualified immunity, reject the findings and recommendation, and set this matter for a jury trial. Right? So then we got our table of authorities and the references on how they're applied. Okay. And then the argument. The original text of Section 1983 explicitly abrogated all common law immunities. The magistrate judge relied upon a Scrivener's error. The magistrate judge's qualified immunity analysis begins with the unstated premise that Congress, in enacting the Civil Rights Act of 1871, intended to incorporate common law immunities for state and local officers. This premise is not merely incorrect, it is the precise opposite of what Congress enacted. The original text of the statute, as passed by the 42nd Congress and signed by President Ulysses S. Grant on April 20th of 1871, contained a notwithstanding clause that explicitly overrode all state law customs, usages, and immunities. Professor Alex Reiner of Cardoso's School of Law, in his landmark article, Qualified Immunities Flawed Foundation, in 2023, unearthed the original text of the Civil Rights Act of 1871 from the statutes at large. The statute was the statute as enacted read, in relevant part, quote, any person who, under the color of any law, statute, ordinance, regulation, custom, or usage of any state, shall subject or cause to be subject any person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution of the United States shall, any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary, notwithstanding, be liable to the party injured in any action at law, suit in equity, or other proper proceeding for redress, unquote. The italicized notwithstanding clause is the critical text. It was a deliberate affirmative statement by Congress that no state law, custom, usage, or immunity, including common law immunities for officers, could defeat liability under the new statute. Congress wrote this clause specifically because the Reconstruction Congress understood that Southern states would attempt to invoke state law, customs, and immunities to shield officers who violated the constitutional rights of freedmen. The notwithstanding clause was Congress's answer. Notwithstanding to any such state law defense, the officer shall be liable. For reasons that remain unexplained, the reviser of federal statutes amended the notwithstanding clause when he compiled the first edition of the revised statutes of the United States in 1874. This was not a legislative act. Congress did not repeal or amend the notwithstanding clause, okay? So they didn't repeal or amend the notwithstanding clause, so it's still in effect, bro. A single unelected reviser whose accuracy was so poor that Congress ultimately fired him simply failed to copy it. As Professor Reiner documents, quote, the distinction between Section 1983 as enacted and as reflected in the United States Code is not the product of any positive lawmaking, unquote. The reviser's error was never corrected in subsequent editions of the United States Code. The Supreme Court has consistently held that the revised statutes and the United States Code are not themselves law. They are merely evidence of law. See United States versus Weldon, okay, in 1964. Again, let's read this one more time. The Supreme Court has consistently held that the revised statutes and the United States Code are not themselves law. They are merely evidence of the law, okay? See United States versus Weldon, okay? In 1964, quote, the code cannot prevail over the statutes at large when the two are inconsistent, unquote. The statutes at large control. The statute at large contained the notwithstanding clause. The notwithstanding clause abrogates all common law immunities. The magistrate judge's application of qualified immunity violates the express enacted will of Congress, okay? You can't get past that, bro. There's going to be major arguments here with this. This is not merely an academic argument. The Supreme Court's doctrine of qualified immunity rests entirely on the premise that Congress, in enacting Section 1983, intended to preserve common law immunities, Harlow versus Fitzgerald. Quote, we therefore hold that government officials performing discretionary functions generally are shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. That premise is false. Congress intended the opposite. The notwithstanding clause proves it. The magistrate judge's qualified immunity analysis is built on a foundation of sand. Hensley versus Floor Copeland 2026. Justice Thomas's 5 principles categorically preclude qualified immunity for Officer Delancey. Even setting aside the original text of Section 1983, the Supreme Court's decision in Hensley versus Floor, issued just 6 weeks after the magistrate judge's findings and recommendation, establishes 5 governing principles that categorically preclude the application of qualified immunity to Officer Delancey. Although Hensley addressed the U.S.C. governmental contract defense rather than qualified immunity directly, the principles of Justice Thomas's articulated apply with equal, if not greater, force to the judge-made doctrine of qualified immunity. The 6-justice majority in Hensley, compromising Justice Thomas and all the others, is precisely the cross-ideological coalition that has, in various individual writings, expressed skepticism about qualified immunity. Justice Thomas himself, in his concurrence in Ziegler versus Abbasi in 2017, wrote, quote, we have substituted our own policy preferences for the mandates of Congress by conjuring up blanket immunity and then failed to justify our enacted policy, unquote. The principles he articulated in Hensley are logical extension of that critique. Principle 1, no immunity without constitutional text or federal statute. Hensley reaffirmed that, quote, there is no federal preemption in vacuo without a constitutional text or a federal statute to assert it, quoting Puerto Rico Department of Consumer Affairs versus Isla Petroleum Corp. In 1988. The federal restrictions or rights that are said to conflict with state law must stem from either the Constitution itself or a valid statute enacted by Congress. Application to this case, Section 1983 contains no immunity provision. It states, without qualification, every person who, under the color of any state statute, subjects any citizen to the deprivation of any rights shall be liable to the party injured. 42 U.S.C. Section 1983, the words shall be liable are absolute. There is no constitutional provision and no federal statute that grants qualified immunity to Officer Delancey. Under Hensley's first principle, qualified immunity cannot exist in this case. Principle 2, judge-made defenses apply only when the government directed the exact conduct complained of. Hensley held that judge-made defenses shield an actor, quote, only when it is being sued precisely for accomplishing what federal government requested, quoting Correctional Services Corp. Versus Malesko in 2001. Because Floor is alleged to have acted outside the authority the military granted it, U.S.C. does not apply. Application to this case. The city of Hood River never directed, authorized, or requested Officer Delancey to invoke obstruction of justice, a charge Delancey admitted under oath does not exist in Oregon. 2, arrest a parked motorist without asking for his identification. 3, seize a citizen's cell phone without a warrant. 4, use force against a cooperative individual with a prosthetic limb who was asking for badge numbers. Delancey acted entirely outside the authority granted to him. Under Hensley's second principle, no judge-made defense can shield him. Principle 3, Congress knows how to write immunity when it wants to, and it did not do so in Section 1983. Hensley noted that Congress knows full well how to make its intention to preclude private liability known. Citing specific examples of explicit immunity provisions Congress has enacted in other statutes, 42 U.S.C. subsection 233A and G, immunity for federally funded health center employees, or 50 U.S.C. section 2783B, immunity for atomic weapons testing contractors. Application to this case. Congress enacted the Westfall Act, 28 U.S.C. section 2679, to immunize federal employees. Congress enacted the Foreign Sovereign Immunities Act, 28 U.S.C. section 1602, to immunize federal sovereigns. Congress enacted the Federal Tort Claims Act of 28 U.S.C. section 2671 to govern suits against the federal government. In every instance where Congress wanted immunity, it wrote immunity. In Section 1983, Congress wrote the opposite, shall be liable. The magistrate judge cannot read an immunity into a statute that Congress deliberately chose not to include. Principle 4, courts cannot extend judge-made defenses beyond their narrower original scope. Hensley rejected the Fourth Circuit's extension of a narrow defense into a broad shield, holding that the lower court not only extended but contradicted the original doctrine. Perfect for us, man. The court emphasized that it, quote, declines to extend the doctrine to bar allegations such as plaintiffs, unquote. Application to this case. Qualified immunity was originally a narrow good faith defense for officers who acted under a mistaken but reasonable belief that their conduct was lawful. Pearson versus Rand, 1967. The court then rewrote it entirely in Harlow versus Fitzgerald in 1982, abandoning the subjective good faith test and replacing it with an objective, clearly established law standard, a standard that has made it nearly impossible for any plaintiff to prevail. The court then further extended it in Pearson versus Callahan in 2009, allowing courts to skip the constitutional question entirely. Under Hensley's fourth principle, each of these extensions was illegitimate. The doctrine must be confined to its original narrow scope. Even in its original scope, it cannot protect an officer who fabricated a crime. Principle 5, no immunity for conduct the government never authorized. Hensley held that, quote, contractors do not automatically share the government's immunity merely because they perform services for it, unquote. The court emphasized that a judge-made defense shields a contractor only when it is being sued precisely for accomplishing what the federal government requested. Where the contractor acted outside the authority of the military granted it, no defense applies. Application to this case. Officer Delancey does not automatically share the city of Hood River's sovereign immunity merely because he wears a badge. The city never authorized, directed, or requested the fabrication of obstruction of justice as a detention mechanism. The city never authorized arresting a man who had committed no crime and who was asking for badge numbers. The city never authorized seizing a cell phone from a citizen exercising his First Amendment rights. Under Hensley's fifth principle, qualified immunity cannot shield conduct the government never authorized. No one gives what he does not have. The city cannot give Delancey immunity for conduct the city never sanctioned. 3. The magistrate judge's qualified immunity analysis is built entirely on a post hoc rationalization that violates Daubert versus Alford. The magistrate judge's qualified immunity analysis is premised entirely on the Venn inspection statute, a rationale that was never invoked by Officer Delancey at the time of arrest. This approach violates the fundamental rule that probable cause must exist for the offense actually invoked at the moment of arrest, not for some other offense that the officer of a court later conjures to justify the arrest. While it is a perfectly reasonable inference that an officer who makes an arrest on the basis of one offense might also have probable cause to arrest for a related defense, we have never held that the offense establishing probable cause must be closely related to and based on the same conduct as the offense identified by the arresting officer at the time of the arrest, unquote. The body-worn camera transcript is unambiguous. At the moment of arrest, Officer Delancey stated, quote, I'm detaining you for obstruction of justice, unquote. He did not invoke the Venn statute. He did not mention ORS 803.305 or any other Oregon statute. He invoked obstruction of justice. Under oath in his deposition, Officer Delancey admitted, quote, obstruction of justice is not even a statute in Oregon, unquote. A charge that does not exist cannot provide probable cause. Beck versus Ohio. Quote, whether that arrest was constitutionally valid depends in turn upon whether at the moment of arrest was made that the officer had probable cause to make it, unquote. There was no probable cause. There was no lawful arrest. There can be no qualified immunity for arrest made without probable cause for a charge that does not exist. The magistrate judge's attempt to substitute the Venn statute as a post hoc rationalization is precisely what Davenport and its progeny forbid. The Venn statute was raised only after plaintiff was already in handcuffs. The transcript establishes this timeline with precision. Qualified immunity cannot be built on a foundation of post hoc rationalization. Ex post facto justifications for constitutional violations are not a defense. They are an admission that no lawful basis existed at the time of the violation. They in trouble, bro. They in trouble for real. That's why I say I have no worries, bro, because they shooting. They got man. Come on, bro. truly shooting blanks out here. The cross-ideological coalition in Hensley signals the imminent demise of qualified immunity, and this court should not wait for that demise to deny it here. You hear what we're asking here? We're saying, hey, it's well known that qualified immunity is out and really does not apply. It's your responsibility now that I know and I'm bringing it forth with such certainty and principles that you operate in such manner. The 6th Justice majority in Hensley is not an accident. It is a signal. Justice Thomas has written repeatedly about his doubts regarding qualified immunity's historical basis. Ziegler versus Abbasi. Thomas J. concurring, I quote, I have previously expressed my doubts about our qualified immunity doctrine. Justice Gorsuch has expressed similar skepticism. Justice Sotomayor has dissented from qualified immunity grants in numerous cases. Justice Kagan, Justice Barrett, and Justice Jackson joined the Hensley majority without reservation. This court need not wait for the Supreme Court to formally overrule qualified immunity in a future case. The principles articulated in Hensley apply directly to the facts of this case. This court has the authority and the duty to apply those principles now. The Ninth Circuit has recognized that qualified immunity is not absolute and that court must engage in rigorous analysis of whether the specific conduct at issue was authorized and whether it violated clearly established law, Ballentine versus Tucker in 2022. Moreover, the Supreme Court has held that qualified immunity cannot shield an officer whose conduct violates a right that is clearly established even without a case directly on point. Hope versus Pelzer, 2002. Quote, officials can still be on notice that their conduct violates established law, even in novel factual circumstances, unquote. It has been clearly established since, at least, Beck versus Ohio, that an officer cannot arrest a person without probable cause. It has been clearly established since Nees versus Barlett, 2019, that an officer cannot arrest a person in retaliation for protected First Amendment activity. It has been clearly established since Riley versus California in 2014 that an officer cannot seize a cell phone without a warrant. No reasonable officer could have believed that fabricating a non-existent criminal charge, arresting a man who had committed no crime, and seizing his phone were constitutionally permissible. Qualified immunity cannot apply. The magistrate's judge violated Tolan versus Cotton by accepting the defendant's version of disputed facts. The Supreme Court has made it clear that summary judgment stage courts must view the facts most favorable to the non-moving party and must not resolve disputed factual issues. Tolan versus Cotton. By failing to credit evidence that contradicted some of its key factual conclusions, the court improperly weighed the evidence and resolved disputed facts in favor of the moving party. The court in Tolan specifically reversed a grant of qualified immunity in a Section 1983 excessive force case because the lower court had failed to view the facts in light most favorable to the plaintiff, which is exactly what my situation is. The magistrate judge committed precisely the same error here. She stated, I find no contradictions of defendant's facts by the evidence in the record. This statement is objectively false. The officer's own sworn depositions contradict the defendant's characterization of offense at every critical juncture. The F&R finding, number one, the officers conducted a traffic stop on plaintiff. The contradicting deposition, Delancey. It was not a traffic stop in the traditional sense. Griffin. It was a consensual encounter. Okay. Destroys Terry versus Ohio reasonable suspicion analysis. The probable cause based on Venn statute. I am detaining you for obstruction of justice. Obstruction of justice is not even a statute in Oregon. Destroys probable cause under Beck versus Ohio and Devin Peck. Plaintiff walked away from officers. Plaintiff turned to ask for my badge number and was not threatening. Creates a jury question under needs. Venn observed before arrest. Transcript establishes Venn raised only after handcuffing. Plaintiff refused to comply with lawful orders. You've been cordial. No ID was ever requested before arrest. Did you ask for my name? No, I didn't. Badge numbers were provided. Junt deposition. He was prepared to provide badge numbers, but he never did. Each of these contradictions is material. Each creates a genuine dispute to fact that a reasonable jury could resolve in plaintiff's favor. And the substantive law will identify which facts are material. Only disputes over facts that might affect the outcome of the suit under the governing law will properly preclude the entry of summary judgment. Every one of the disputed facts identified above directly affects the outcome under the governing law of the Fourth Amendment, the First Amendment in Section 1983. The magistrate judge was required to resolve the disputes in plaintiff's favor. She did the opposite. The court must correct that error. The constitutional and the federal rules of civil procedure strictly limit the magistrate judge's role at summary judgment. Okay? So the Constitution and the rule of civil procedure strictly limit a judge's role at summary judgment. When material facts are disputed, the judge's task is not to decide which version is true, which is what she did, okay? But only to determine whether a reasonable jury could find for non-moving party. Anderson versus Liberty Lobby. At the summary judgment stage, the judge's function is to not himself to weigh the evidence and determine the truth of the matter, but to determine whether there is a genuine issue for trial. The Seventh Amendment guarantees the right to a jury trial on the disputed facts. So, the magistrate judge's decision to resolve disputed facts in the defendant's favor, and to do so by declaring that no contradictions exist when the officer's own testimony proves they do, is a violation of the Constitution's separation between the judicial function and the jury function. The Supreme Court has emphasized this limitation with particular force in Section 1983 cases. Tolan versus Cotton, quote, courts may not resolve genuine disputes of fact in favor of the party seeking summary judgment, unquote. The magistrate judge crossed that line. This court must pull the case back to its correct side of it. Again, so then we're going into the conclusion and the prayer for relief. The convergence of the three independent legal developments compels the denial of qualified immunity in this case and the rejection of the magistrate judge's findings and recommendations. First, the original unadulterated text of the Civil Rights Act of 1871 contained a notwithstanding clause that explicitly abrogated all state law immunities. The magistrate judge applied a doctrine that Congress itself prohibited in the statute's original text. Second, the Supreme Court's decision in Hensley versus Floor Corp establishes five governing principles that categorically preclude qualified immunity for conduct the government never authorized. The city of Hood River never authorized Officer Delancey to fabricate a non-existent criminal charge, arrest a man who had committed no crime, or seize a cell phone from a citizen exercising his First Amendment rights. Third, the officer's own sworn depositions and the body camera transcript contradict the magistrate judge's factual findings at every critical juncture. The magistrate judge's declaration that she found no contradiction of defendant's facts by the evidence in the record is objectively false and constitutes a violation of Tolan versus Cotton's mandate to view disputed facts in light most favorable to the non-moving party. Plaintiff Cameron James Wilson, proceeding pro se, respectfully plays this honorable court to accept and consider the supplemental memorandum as a new authority submitted in support of plaintiff's objections. 2, to apply the 5 principles of Hensley versus Floor Corp to deny qualified immunity to Officer Delancey. 3, apply the original text of 42 U.S.C. section 1983, including the notwithstanding clause, to hold that no common law immunity can defeat plaintiff's claims. 4, reject the magistrate judge's findings and recommendations in its entirety. 5, deny defendant's motion for summary judgment in its entirety. 6, set this matter for jury trial on all claims. And 7, grant such other and further relief as this court deems just, proper, and consistent with the Constitution in the United States and the original mandate of the Civil Rights Act of 1871. And so that's the memorandum that's going to be in support of the objections as well. And so that's based off of the Fleur versus Corp, which is hitting pretty hard, which is just a decision that we got, not even 2 weeks ago, maybe about 2 weeks ago. So very, very strong in relation to the objections. So this is going to be filed today, tomorrow, or Monday. I'll probably file it in tomorrow, but I might just file it early in Monday morning so that they have it on the date of the last day. You know what I'm saying? Like, bam, you know what I'm saying? And hit them pretty hard because, like I say, man, just because they will file something on that ass doesn't mean that it's applicable, truly. Just because this judge filed this factual finding on my ass does not mean that it is the last resort, bro, at all. We can see clearly where she erred. So that's why I want y'all to really understand is that going through so much that I've gone through now, hopefully a lot of things that might come up that would make you fearful are kind of, brought down so that way you're not nervous. I think it's, a lot of people be like, oh, well, I need to pack everything in there in my very first complaint. And it's like, do you really? Right? Do you want to give them every card that you have right now? Or do you want to see how they're going to respond and then make an amended complaint? Because you have the right to do an amended complaint within the first 21 days. They will come through and do this summary judgment in hopes that you can't get through it because they've been getting away with it for so many years beforehand. And that's just not necessarily the case these days, right? They've had so many blanket responses and haven't had people really get into the depths of what we've been able to get into the depths of now that we have technology to help us get into those depths, that it is becoming hard for them to combat us, especially when we can articulate a timeline that clearly shows that they have no authority over us whatsoever in the first place, and that their reasoning is completely wrong. On lots of different certain situations. I mean, we got welfare checks all over the place that are getting violated and justified into some kind of articulate crime when they're just not whatsoever. And so, as y'all see, a lot of the things that they're doing to combat me, when I come through and they, are combating me via sir replies in relation to the summary judgment, or I don't think I did a summary judgment initially. I think I did a default judgment on Hood River initially, and the judge, moved in their favor. Cool, no worries. Then we came through and did the depositions, and they filed for summary judgment. And now, we did our sir replies, and she's allowing them to kind of just lie and bring forth things that are truly a lie, and then acquiescing to those lies entirely. Is something that cannot stand, and I do understand that, some people will, like Chili will say, there's no justice that you can get. We're gonna see justice, bro. There's no doubt about it, and I'm not nervous, and hopefully y'all can see as we're going through everything and kind of just what's being thrown my way, that there's still remedy, and we still battle it out. And hey, man, we're out here correcting these judges. The judges make mistakes, and as they continue to make mistakes, we'll just keep combating them. And we'll keep getting our wins. And yeah, this is where we're at. What questions y'all got so far on?
Hey Cam, is that a state action or is that a federal action you're doing?
Everything I'm doing is federal.
Yeah, good. Yeah. Yeah, it's crazy. I know I mentioned to you a little bit on Facebook. You don't get a chance to check those messages a whole lot, but man, I'm in Florida, bro. It's crazy. So I got stopped, right? I had a farm use tag on a little Toyota Prius. And I got the video evidence from the trooper's car last August, and I've been fighting this for 8.5 months. And I went the whole statutory process, right? I went through everything. I learned anything to do with any of the notices, hearings. I issued subpoenas. I mean, the whole night. I learned the whole process, bro, through the whole thing. And I prepared for trial, and we had a pretrial hearing on March 25th, and the state's attorney threatened me with 60 days in jail. And after that, I just kind of laughed at him. I told him he's got to get past Terry versus Ohio before we can get to that stretch. And so we had trial April the 1st, and I had media there because, of course, I had my QSIP. And I had the serial number for the bond, and I'd already made a Facebook post, and it got shared a lot. I told them that the case had been monetized outside of the normal, structure of financial stuff when it comes to court cases. And so we had media there, and we had a pack. The jurors were there. They were doing trial and jury pick the same day. So anyhow, the judge, he told me that I could not use the video evidence from the trooper's car to invalidate the stop. And I was like, what? What are we talking about here? Are you serious? And he was like, yeah. I was like, okay, so I just want to make sure I got a certified copy of your oath of office here. And I just want to make sure I'm understanding you correctly on the record that you're willing to violate all these constitutional protections, and you're willing to give me partial constitutional protections. We're fixing to enter a trial. He said, yeah. He said that evidence is not for the jury to look at. I was like, wow. Crazy, man.
That is kind of weird. And so y'all continued anyways?
Yeah, well, he told the state's attorney, basically, shut up. And he said, the state's attorney don't make the ruling here. He said, I do. He said, I'm not going to put you in jail for 60 days, which I already told him. I was very well of the GSA forms that were filled out on the case. And he acted kind of dumb about it, you know. And I said, well, I told him, I said, I've already filled out a 4506T, and I've already filled out a form PDF 1048. I said, I'm waiting for those documents to come back in. I said, when they come in, I said, I know the case has been monetized, and all three parties have a financial interest in the outcome of this case. And I even filed an affidavit into the case asking them to sign it. Of course, they wouldn't touch that with nothing. So anyhow, he made me an offer of no contest, adjudication withheld, right? And so the only reason why I took that was because under Heck versus Humphreys, I can still file a federal civil action since there's no conviction. I don't have anything to overturn. There's no adjudication withheld. So Heck versus Humphreys allows me to file a civil action in that regard. So that's kind of where I'm at right now. But yeah, Florida's out of control, man.
Florida is out of control, bro. That's like 70% of Wisedome members is Florida. Like, it's crazy out there.
Sound like you're getting desperate.
Yeah,
I mean, I couldn't believe. I was flabbergasted because I showed my presentation to an attorney, and he looked at it and he told me, he said, "Man," he said, "this is crazy." He said, I've seen tenured attorneys 30 years couldn't put this together." The officers, the officer's his own dash cam. He was on private property, bro. So I had a public information request submitted through FHP with the parcel of property, and it showed that my public information request come back from FHP, no contractual nexus on the officer to sit on the private location for a vantage point to gather evidence, you know, for surveillance or anything like that. So not only was he on private property, I had a public information report from FHP that invalidated that his location was rendered unlawful. And when you looked at his dash cam, if he's facing south, his vehicle was in drive and his foot was on the fucking brake. And when I'm coming in from the west, he's already lurching up to meet me. He can't even see there's no infraction even done. And it was a complete targeted stop. It's absolutely crazy. But now, since there was a no proof of insurance citation in that same interaction, now I'm going to try to attack with a new judge. I'm trying to attack it from an unlawful stop point. And then I'm going to try to use that to do a post-conviction overturn.
So you're about to bring forth a civil suit yourself?
Yes, I've got 6 I'm fixing to drop.
6?
Yeah, bro, my shit's crazy. I mean, I can show you some stuff, bro. It's unreal. One of them was the state's attorney told a bailiff to go arrest me in court, and the bailiff has no duty whatsoever to listen to a state's attorney. The state's attorney doesn't have any type of authority to tell a bailiff to do anything. I've got a smorgasbord of stuff that I'm fixing to come through.
What part of Florida are you from?
I'm up here in the Panhandle. Yeah, I'm up here in the Panhandle.
Well, it seems like it's the same way in Hillsborough County too.
Yeah, man, they're just completely out of control, man. I had one judge disqualified because he looked at the state's attorney and he was like, "Hey," he's like, "What's the state's assertion of Mr. Layfield trying to assert someone else's Fourth Amendment, property rights?" And I said, "Objected." I said, "Objection. You're a tenured judge asking the state's attorney for a legal conclusion of law." I said, "You're supposed to be unbiased." Like, what in the hell, man? Like, it's crazy, bro. They just do whatever they want to do.
And you say you got a recusal of that one?
Yeah, no, he was disqualified right off the rip. And I had another one recused. So I had one recusal, one disqualification, and then I didn't hear nothing from him for like 3 months. And then because they wouldn't answer any of my interrogatories, they just went silent for a long, long time, right? And listen to this crap. The charging instrument was completely unverified. Nothing. It was just a fucking piece of paper, bro. And I told him, I was like, "Look,
so
the
no
state's
oath or
attorney has to
affirmation?
show up." What's that?
No oath or affirmation?
No, correct. And so even under 3140G in Florida, it didn't even meet any of the requirements for a valid charging instrument. And then check this out. This is what's really crazy. At the beginning, I had 2 citations. Well, one was for no proof of insurance. The first one was no registration, right? So the officer gave me a notice to appear of August the 12th. Well, they towed the vehicle. Man, this is crazy as fuck, dude, what I'm fixing to tell you, but it's nuts. So they towed the vehicle. So I had to stop a fisherman to get a ride home. So I got a ride home and I lost the citation. Well, I emailed the clerk like a week later. I was like, hey, I need to know when my notice to appear is. So she sent me a notice to appear in the mail. So I got it and I was like, wait, this is not the notice to appear. It's on citation. Well, I found my original citation and I was like, okay, this says August the 12th. That's the officers. And the clerk is saying August the 7th. So when I went to arraignment, I said, I'm here under duress by way of special appearance pursuant to Rule 3.190 of the Florida Rules of Criminal Evidence. And this is a jurisdictional defect. And everybody got quiet. And I said, I've got 2 charging instruments. I got 2 citations, 2 notice to appears. I said, so and the judge was like, well, that's not prejudicial. I said, you can say that. I said, but if I wouldn't have showed up to this arraignment, I'd been in jail. You understand what I'm saying? So if 3.125C says you're supposed to serve me personally, then if you amended the charging instrument or the notice to appear, I'm supposed to get personal service. You can't send it through the regular mail, right? And they just ignored everything, bro. It's like absolute clusterfuck. It's crazy. So, but yeah, they're just wild, man. But I had no choice. Like we had jurors there, and I had spent all this time. I spent over 1,000 hours on this case getting all this shit compiled. And for the judge just to say, hey, we can't show the jurors the evidence, I was like, what in the actual fuck?
So, are you familiar with the 3.190C4 motion then?
I'd have to look it up.
Yeah, in Florida, that's the one that hits with sworn statements arguing each element, and that the state has to respond via demur or traverse.
Really?
And if they don't respond via traverse or demur, it's an automatic dismissal.
Man, they just
3.19, yeah, 3.190C4.
I'll go back and look it up, but check this out. So in state of Florida, the troopers got what's called a TL-26. That's their tow log. The trooper has to sign it, and then the tow truck driver's got to sign it. Well, they towed the vehicle, and I went up there. I told the tow company, I was like, look, there's no signature on the TL-26. In Court of Florida statute, you can't lien or retitle the vehicle, right?
Right.
So I did my inspection through DMV. I got all my inspection report back, right? The motherfucker retitled the vehicle with a fake affidavit in December, and I still ain't got the vehicle back. I can do a writ to get the vehicle back, but he's already retitled the thing. He filled out a false affidavit through the DMV. I give him notice twice. I give the DMV, the lady at the DMV, her name's Chris Rogers. I mean, she's the director there. I gave her an email twice. I told her, I said, this VIN number, if it comes through here, the TL-26 is not signed. I said, so you can't retitle or anything with the vehicle. And they went through and did it. Everything went through her office. So I filed a civil action in county civil for $110,000. Predatory towing practices, conversion using a state instrument. Man, there's all kind of counts. It's criminal too. But
when did you do that one?
January.
What's been going on with it?
They have set it for trial in August of 27.
So what, you're just working on discovery and everything right now?
Yeah.
You gonna be doing depositions or what?
Absolutely.
Oh, you already got something under the ringer?
Nope, not yet.
Oh. What?
But yeah, they're just wild, man. I mean, it's crazy.
It is pretty crazy out here. But I'm kind of the first one, so I'm a little bit further along. But we got Robert. He done hit for his. Hayden's about to hit for his. Kane's about to hit for his. We got a lot of people. It's lawsuit season, bro. Like
Oh
it's
yeah, for
lawsuit
sure.
season. James is about to hit for his. There's a lot of people bringing. Robin's about to hit for his. There's a lot of people bringing forth lawsuits, bro, right now. So it's pretty crazy how many people we got bringing them forth. But it's time. So
It is.
yeah,
He's another sovereign.
telling you, bro, we ain't playing no more with it. Got to bring them forth now because they just doing too much. So,
Well, a lot of things, like you said, a lot of times people are scared, man. You know what I'm saying? I'm not scared at all, bro. And I learned, you know, I'm talking about everything to do with the Florida rules of criminal procedure. I mean, anything to do with, I mean, I issued subpoenas to the state trooper. I issued subpoenas to the clerk. Because here's the thing, when you've got two conflicting charging instruments like that, that's a major jurisdictional defect right there. Big time. And they
where are
just
you challenging that? And are you challenging that at the beginning or no?
Yeah, of course I challenged it right off the jump, you know, and they
Mm.
just said it was a harmless error. I said, no, it's not a harmless error because if I wouldn't have showed up to arraignment, I said if I would have come, if I would have been here on the other date instead of this date, you would have sent a warrant for my arrest. Period. So
Right.
that's not harmless. That's a
Right.
due process violation. There's nothing harmless about that.
Right.
You know, you try to
Yeah.
explain that to the judge, and they just kind of, it's just a typographical error. It's just an administrative error. Well, violation of my rights is not an error.
See, I don't be having people hit too hard on the jurisdiction aspect up front, just because I know that they can hit it any other time. So
Mm-hmm.
once you get multiple grounds or multiple violations, then it's even more powerful rather than
Yeah.
just utilizing that. Because they always just like to say, "Oh, well, that's sovereign citizen stuff," and then people are just having a hard time arguing it out. But yeah, we've been putting them on lock according to the criminal rules of procedure pretty heavily, bro. In Florida right now, what's working is again, yeah, that C4 motion 190. I mean 3.190 C4 is where it's at right now, and where people are getting a good amount of success. So because the state don't want to answer back with a traverse or demur, and they must when they bring forth the C4 motion like that. So it's been pretty cool in relation to that, and most of the other states have those same rules within their procedure on the state side. So it's just finding out which rule it is and then utilizing it back. So
The best thing I could say that come out of it is that, you know, that I do know the procedure when most people don't know the procedure. I've learned it on the fly. You know what I'm
right,
saying? So
yeah,
I'm not scared a bit. I mean, I'll get in there and get with them. You know, I mean, I'll get in there and get nasty with them. You know what I'm saying? So as long as you're competent, you know what I'm saying, your confidence will follow. And that's what I like about going in there. You know what I'm saying? It's like when you learn all that, they thought they was just going to drag somebody through the fucking mud. But here I'm in, you know, here I am going in there with them. And, you know, I know all the rules procedure. You know, I said, look, I told the state's attorney, I mean, hell, I'm 51. He was sitting over there. He's like 35 years old. And I was like, who is this young man right here? I said, he's never even formally appeared on a record. I said 2.505E says every attorney, every bar member shall make a formal appearance on the record. And I said he's made none. So who am I talking to? You know?
Ah, got him. They
that's a
thought
good
they
one.
had one just
Yeah,
to rush through like Walmart, get your shit and get out.
Yeah, yeah, yeah.
yeah,
But
that's a
like I
good one.
said, I mean, I appreciate the experience I've gotten through there. You know what I'm saying? So it's like I'm not worried about it. It's going to help me in the other areas. And I wouldn't even commence on a federal action if it wasn't legit. You know what I'm saying?
Right.
So like nothing's frivolous on my end. But you know, just my scenario is I look at it like this: if motherfuckers gonna pull you over for like a rolling stop or like bullshit, and if they're gonna be petty, motherfucker, I'm gonna be petty too. You think you was petty? I'm gonna be petty as fuck, but I'm coming with facts. If you violate my rights, man, I'm coming. Period.
Right. That's the same with us, man. That's the same with
I
us.
love it.
Yeah, me too. Okay. For the recording on this one, we're gonna end it out on that one. Everybody, if y'all can unmute and just tell the world goodbye, world, or however you want to say your goodbyes. Yeah, unmute for this one.
Deuces.
Yeah, let them know.
Hell yeah.
Peace out.
Goodbye, world.
Yeah.
Have a good
Adios,
weekend.
amigos.
Yeah, man. Yeah, man.
Bye.